Section 7, Answer Key National Test 1, Rights, Interests and Estates, Ownership 1.1, A. Wells, driveways, and signs on a parcel of land. The legal concept of real estate encompasses land and all man-made structures that are permanently attached to the land. The phrase permanently attached refers primarily to one's intention in attaching the item. Obviously, very few if any man-made structures can be permanently attached to the land in the literal sense. But if a person constructs a house with the intention of creating a permanent dwelling, the house is considered real estate. By contrast, if a camper affixes a tent to the land with the intention of moving it to another camp in a week, the tent would not be considered real estate. 1.2. C. A chicken coop permanently attached to land. Improvements to real estate include such things as fences, streets, buildings, wells, sewers, sidewalks, and piers. Modifications to land or a developer's preparations of a parcel of land can include such activities as grading or clearing, neither of which are considered to be improvements in the sense of the word. 1.3. B. The center of the earth and infinite space above the earth. The legal concept of land encompasses the surface area of the earth, everything beneath the surface of the earth extending downward to its center, all natural things permanently attached to the earth, and the air above the surface of the earth extending outward to infinity. Land, therefore, includes minerals beneath the earth's surface, water on or below the earth's surface, and the air above the surface. 1.4. A. Enjoyed by the owner of a property. This group of rights includes the right to possess, use, transfer, encumber, and exclude others from using the property. Remember, putti, transfer rights include the right to sell, rent, donate, assign, or bequeath. The owner may also encumber the item by mortgaging it as collateral for debt. 1.5. B. Any item of property that is not definable as real property. Personal property is any owned item which is not real estate, and the rights associated with owning the personal property item. Items of personal property are also called chattels or personalty. 1.6. B. Pledge the property as collateral for debt. The right to encumber the property essentially means the right to mortgage the property as collateral for debt. There may be restrictions to this right, such as a spouse's right to limit the degree to which a homestead may be mortgaged. 1.7. A. Transfer of a portion of the bundle of rights. An ordinary lease is a common example of the transfer of a portion of one's bundle of rights. The owner relinquishes the right to possess portions of the surface, perhaps a building, in return for rent. The tenant enjoys the rights to possess and use the building over the term of the lease, after which these rights revert to the landlord. During the lease term, the tenant has no rights to the property's subsurface or airspace other than what the building occupies. Further, the tenant does not enjoy any of the other rights in the bundle of rights. He or she cannot encumber the property or transfer it. To a limited degree, the tenant may exclude persons other than the legal owner from the property. 1.8. D. Yes. The drones infringe on his air rights. Air rights apply to the space above the surface boundaries of the parcel, as delineated by imaginary vertical lines extended to infinity. Since the advent of aviation, property owners' air rights have been curtailed to allow aircraft to fly over one's property provided the overflights do not interfere with the owner's use and enjoyment of the property. The issue of violation of air rights for the benefit of air transportation is an ongoing battle between aircraft owners, airlines, airports, and nearby property owners. 1.9. C. Navigable lakes, seas, and oceans. Littoral rights concern properties abutting bodies of water that are not moving, such as lakes and seas. Owners of properties abutting a navigable, non-moving body of water enjoy the littoral right of use, but do not own the water nor the land beneath the water. The legal premise underlying the definition of littoral rights is that a lake or sea is a navigable body of water, therefore, public property owned by the state. By contrast, a body of water entirely contained within the boundaries of an owner's property is not navigable. In such a case, the owner would own the water as well as unrestricted rights of usage. 1.10. A. The high water mark of the body of water at the shoreline. Ownership extends to the high water mark of the body of water. The low water mark would imply that the owner owned the water itself at times of high water levels. 1.11. D. They transfer with the property when the property is sold. Littoral rights attach to the property. When the property is sold, the littoral rights transfer with the property to the new owner. 1.12. C. Streams and rivers. Riparian rights concern properties abutting moving water such as streams and rivers. If a property abuts a stream or river, the owner's riparian rights are determined by whether the water is navigable or not navigable. If the property abuts a non-navigable stream, the owner enjoys unrestricted use of the water and owns the land beneath the stream to the stream's midpoint. If the waterway in question is navigable, the waterway is considered to be a public easement. In such a case, the owner's property extends to the water's edge as opposed to the midpoint of the waterway. 1.13. B. An item of personal property that has been converted to real property. A personal property item that has been converted to real property by attachment to real estate is called a fixture. Typical examples are chandeliers, toilets, water pumps, septic tanks, and window shutters. The owner of real property inherently owns all fixtures belonging to the real property. When the owner sells the real property, the buyer acquires rights to all fixtures. 1.14. A. The owner originally intended to remove it after a period of time. One's original intention can override the test of movability in determining whether an item is a fixture or not. If someone attached an item to real property, yet intended to remove it after a period of time, the article may be deemed personal property. If a person intended an article to be a fixture, even though the item is easily removable, the article may be deemed a fixture. For example, an apartment renter installs an alarm system, fully intending to remove the system upon lease expiration. Here, the alarm system would be considered personal property. 1.15 c. 50% of the estate consisting of the indivisible whole of the real property. An undivided interest is an owner's fractional interest in an entire, undivided, estate, but not in a physical portion of the real property itself. An owner who has an undivided equal interest with another cannot exercise exclusive rights over a portion of the real estate, which is an indivisible whole. 1.16 a. An estate in land. Interests are principally distinguished by whether they include possession. If the interest holder enjoys the right of possession, the party is considered to have an estate in land, or, familiarly, an estate. Freehold and leasehold estates in land are further distinguished by whether the duration of the owner's rights can be determined. 1.17 a. A public interest. Public entities may own or lease real estate, in which case they enjoy an estate in land. However, government entities also have non-possessory interests in real estate which act to control land use for the public good within the entity's jurisdiction. The prime example of public interest is police power, or the right of the local or county government to zone. Another example of public interest is the right to acquire ownership through the power of eminent domain. 1.18 c. A freehold estate. In a freehold estate, the duration of the owner's rights cannot be determined. The rights may endure for a lifetime, for less than a lifetime, or for generations beyond the owner's lifetime. By contrast, leasehold estates have expirations. 1.19 d. That the estate is limited by a lease term. A leasehold estate is distinguished by its specific duration, as represented by the lease term. Further, leasehold tenants only enjoy limited property rights, use, temporary possession, and limited exclusion. 1.20 d. Fee simple defeasible. The defeasible fee estate is perpetual, provided the usage conforms to stated conditions. Essential characteristics are that the property must be used for a certain purpose or under certain conditions, and, if the use changes or if prohibited conditions are present, the estate reverts to the previous grantor of the estate. 1.21 c. An ordinary life estate. A life estate is limited in duration to the life of the owner or other named person. Upon the death of the owner, ordinary life estate, or other named individual, per otravi life estate, the estate passes to the original owner, a reversionary interest, or another named party, a remainder interest. Thus with the life estate, the owner enjoys full ownership rights during the estate period, and holders of the future interest own either a reversionary or a remainder interest. 1.22 b. A legal life estate. Homestead, dower, and curtsy are legal life estates. A legal life estate is created by state law as opposed to being created by a property owner's agreement. The focus of a legal life estate is defining and protecting the property rights of surviving family members upon the death of the husband or wife. 1.23 b. The boat, house, and motorcycle. Separate property consists of property owned by either spouse at the time of the marriage, property acquired by either spouse through inheritance or gift during the marriage, property acquired with separate property funds, and income from separate property. Community property consists of all other property earned or acquired by either party during the marriage. A spouse owns separate property free and clear of claims by the other spouse. He or she can transfer it without the other spouse's signature. Upon the death of the separate property owner, the property passes to heirs by will or laws of descent. Community property cannot be transferred or encumbered without the signatures of both spouses. Upon the death of either spouse, half of the deceased's community property passes to the surviving spouse, and the other half passes to the decedent's heirs. 1.24 d. The right to possess and use the premises. Leasehold tenants are entitled to possess and use the leased premises during the lease term in the manner prescribed in the lease. They also have restricted rights to exclusion. 1.25 a. The tenant makes, and landlord accepts, regular rent payments. In an estate from period to period, also called a periodic tenancy, the tenancy period automatically renews as long as the tenant pays rent in a timely manner and the landlord accepts it. At the end of a tenancy period, if the landlord accepts another regular payment of rent, the leasehold is considered to be renewed for another period. A conveyance of leased property does not cancel a leasehold interest. 1.26 c. Terminates on the death of lessor or lessee. The estate at will, also called a tenancy at will, has no definite expiration date and hence no renewal cycle. The landlord and tenant agree that the tenancy will have no specified termination date, provided rent is paid on time and other lease conditions are met. For example, a son leases a house to his father and mother forever, or until they want to move. The estate at will is terminated by proper notice, or by the death of either party. 1.27 a. An estate at sufferance. In an estate at sufferance, a tenant occupies the premises without consent of the landlord or other legal agreement with the landlord. Usually such an estate involves a tenant who fails to vacate at the expiration of the lease, continuing occupancy without any right to do so. For example, a tenant violates the provisions of a lease and is evicted. The tenant protests and refuses to leave despite the eviction order. 1.28 b. Estate from period to period. In an estate from period to period, also called a periodic tenancy, the tenancy period automatically renews for an indefinite period of time, subject to timely payment of rent. At the end of a tenancy period, if the landlord accepts another regular payment of rent, the leasehold is considered to be renewed for another period. 1.29 a. Tenancy in severalty. If a single party owns the fee or life estate, the ownership is a tenancy in severalty. Synonyms are sole ownership, ownership in severalty, and estate in severalty. 1.30 c. Tenancy in common. The tenancy in common, also known as the estate in common, is the most common form of co-ownership when the owners are not married, though tenants in common can be married. The defining characteristics are, 2 or more owners, identical rights, interests individually owned, electable ownership shares, no survivorship, and no unity of time. With identical rights, co-tenants share an indivisible interest in the estate, i.e., all have equal rights to possess and use the property subject to the rights of the other co-tenants. 1.31 a. Parties must acquire respective interests at the same time. To create a joint tenancy, all owners must acquire the property at the same time, use the same deed, acquire equal interests, and share in equal rights of possession. These are referred to as the four unities. 1.32 b. Cannot will their interest to a party outside the tenancy. The survivorship feature of joint tenancy presents an advantage to tenancy in common, in that interests pass without probate proceedings. On the other hand, joint tenants relinquish any ability to will their interest to parties outside of the tenancy. 1.33 c. Legal life estate. A legal life estate is created by state law as opposed to being created by a property owner's agreement. The focus of a legal life estate is defining and protecting the property rights of surviving family members upon the death of the husband or wife. 1.34 a. A homestead interest cannot be conveyed by one spouse. A homestead is one's principal residence. Homestead laws protect family members against losing their homes to general creditors attempting to collect on debts. Homestead laws generally provide that the homestead interest cannot be conveyed by one spouse, both spouses must sign the deed conveying homestead property. 1.35 a. Sell or transfer his interest without the consent of the other tenants in common. All tenants in common have distinct and separable ownership of their respective interests. Co-tenants may sell, encumber, or transfer their interests without obstruction or consent from the other owners. A co-tenant may not, however, encumber the entire property. 1.36 c. Income derived from community property. If an income-producing property has been defined as community property, the revenue accruing from the investment is likewise community property. 1.37 c. The beneficiary. A land trust allows the trustor to convey the fee estate to the trustee and to name himself or herself the beneficiary. The land trust applies only to real property, not to personal property. The agreement, or deed in trust, grants the beneficiary the rights to possess and use the property, and to exercise control over the actions of the trustee. 1.38 c. The Buick and the Second Property Community property laws define property rights of legal spouses before, during, and after their marriage, as well as after the death of either spouse. Community property law distinguishes real and personal property into categories of separate and community property. Separate property belongs to one spouse, community property belongs to both spouses equally. Separate property is that property which is acquired prior to the marriage, by gift or inheritance during the marriage, property acquired by separate property funds, or income from separate property. 1.39 a. A cooperative may hold an owner liable for the unpaid operating expenses of other tenants. Since the corporation owns an undivided interest in the cooperative, property, debts, and financial obligations apply to the property as a whole, not to individual units as in a condominium. 1.40 b. The owners enjoy an indivisible interest. The tenancy in common, also known as the estate in common, is the most common form of co-ownership when the owners are not married, though tenants in common can be married. The defining characteristics are: two or more owners, identical rights, interests individually owned, electable ownership shares, no survivorship, and no unity of time. With identical rights, co-tenants share an indivisible interest in the estate, i.e., all have equal rights to possess and use the property subject to the rights of the other co-tenants. 1.41 a. Sell her interest to a third party without the consent of Robert. All tenants in common have distinct and separable ownership of their respective interests. Co-tenants may sell, encumber, or transfer their interests without obstruction or consent from the other owners. A co-tenant may not, however, encumber the entire property. 1.42 d. It passes by probate to the deceased tenant's heirs. A deceased co-tenant's estate passes by probate to the decedent's heirs and devises rather than to the other tenants in common. Any number of heirs can share in the ownership of the willed tenancy. 1.43 c. The tenants have an equal and indivisible ownership interest. In a joint tenancy, two or more persons collectively own a property as if they were a single person. Rights and interests are indivisible and equal, each has a shared interest in the whole property which cannot be divided up. Joint tenants may only convey their interests to outside parties as tenant in common interests. One cannot convey a joint tenant interest. 1.44 a. There is a single title to the property. Whereas tenants in common hold separate title to their individual interests, joint tenants together hold a single title to the property. This is referred to as unity of ownership. 1.45 a. The new owner becomes a tenant in common with the other owners, who continue to hold a joint tenancy with each other and a tenancy in common with the new owner. A joint tenant may transfer his or her interest in the property to an outside party, but only as a tenancy in common interest. Whoever acquires the interest co-owns the property as a tenant in common with the other joint tenants. The remaining joint tenants continue to own an undivided interest in the property, less the new co-tenants' share. 1.46 d. It passes to the surviving joint tenants. In most states, joint tenants enjoy rights of survivorship. If a joint tenant dies, all interests and rights pass to the surviving joint tenants free from any claims of creditors or heirs. When only one joint tenant survives, the survivor's interest becomes an estate in severalty, and the joint tenancy is terminated. 1.47 c. If they are married. Tenancy by the entire ties is a form of ownership reserved exclusively for husband and wife. It features survivorship, equal interests, and limited exposure to foreclosure. 1.48 c. The trustee. In an estate in trust, a fee owner, the grantor or trustor, transfers legal title to a fiduciary, the trustee who holds and manages the estate for the benefit of another party, the beneficiary. The trust may be created by a deed, will, or trust agreement. 1.49 a. Sell or mortgage the unit without impediment from individual owners of neighboring units. Condominium units can be individually sold, mortgaged, or otherwise encumbered without interference from other unit owners. An owner may not sell interests in the apartment separately from the interest in the common elements. Unit owners exclusively possess their apartment space, but must share common areas with other owners. 1.50 b. The unit's pro rata share of the property value as defined in the declaration. The unit's pro rata share of the property's ownership as defined in the declaration determines the amount of a unit owner's assessment. For example, if a unit represents a 2% share of the property value, that unit owner's assessment will be 2% of the property's common area expenses. 1.51 a. Shares in a corporation or association and a proprietary lease in a physical unit. In a cooperative, or co-op, one owns shares in a non-profit corporation or cooperative association, which in turn acquires and owns an apartment building as its principal asset. Along with this stock, the shareholder acquires a proprietary lease to occupy one of the apartment units. 1.52 d. The corporate entity of the cooperative association. The corporate entity of the cooperative association is the only party in the cooperative with a real property interest. The association's interest is an undivided interest in the entire property. There is no ownership interest in individual units, as with a condominium. 1.53 a. Undivided interests in the property as tenants in common. In a freehold timeshare, or interval ownership estate, tenants in common own undivided interests in the property. Expense prorations and rules governing interval usage are established by separate agreement when the estate is acquired. National Test 2, Encumbrances, Liens, Title Transfer and Recording, Leases 2.1, c. A third party's interest in a real property that limits the interests of the freehold property owner. An encumbrance is an interest in and right to real property that limits the legal owner's freehold interest. In effect, an encumbrance is another's right to use or take possession of a legal owner's property, or to prevent the legal owner from enjoying the full bundle of rights in the estate. 2.2 a. They involve the property that contains the easement and a non-owning party. An easement is an interest in real property that gives the holder the right to use portions of the legal owner's real property in a defined way. One cannot own an easement over one's own property. Easement rights may apply to a property's surface, subsurface, or airspace, but the affected area must be defined. An easement may be affirmative, allowing a use, such as a right-of-way, or negative, prohibiting a use, such as an airspace easement that prohibits one property owner from obstructing another's ocean view. 2.3 d. An easement appurtenant. An easement appurtenant gives a property owner a right of usage to portions of an adjoining property owned by another party. The property enjoying the usage right is called the dominant tenement, or dominant estate. The property containing the physical easement itself is the servient tenement, since it must serve the easement use. 2.4 C. Easement by necessity. An easement by necessity is an easement appurtenant granted by a court of law to a property owner because of a circumstance of necessity, most commonly the need for access to a property. Since property cannot be legally landlocked, or without legal access to a public thoroughfare, a court will grant an owner of a landlocked property an easement by necessity over an adjoining property that has access to a thoroughfare. 2.5 B. An unauthorized physical intrusion of one property into another. An encroachment is the unauthorized, physical intrusion of one owner's real property into that of another. Examples of encroachments are, a tree limb extending into the neighbor's property, violating his or her airspace, a driveway extending beyond the lot line onto the neighbor's land, and a fence built beyond the property line. 2.6 C. A trespasser has been using an owner's property for a certain period with the owner's knowledge but without permission. If someone uses another's property as an easement without permission for a statutory period of time and under certain conditions, a court order may give the user the easement right by prescription, regardless of the owner's desires. For a prescriptive easement order to be granted, the following circumstances must be true: the use has been occurring without permission or license, the owner knows or is presumed to have known of the use, and the use has been generally uninterrupted over the statutory prescriptive period. 2.7 D. How a property may be used and what improvements may be built on it. A deed restriction is a limitation imposed on a buyer's use of a property by stipulation in the deed of conveyance or recorded subdivision plat. A deed restriction may apply to a single property or to an entire subdivision. A developer may place restrictions on all properties within a recorded subdivision plat. Subsequent resales of properties within the subdivision are thereby subject to the plat's covenants and conditions. 2.8 C. The creditor's claim against the property as collateral security for the loan. A lien is a creditor's claim against personal or real property as security for a debt of the property owner. If the owner defaults, the lien gives the creditor the right to force the sale of the property to satisfy the debt. For example, a homeowner borrows $5,000 to pay for a new roof. The lender funds the loan in exchange for the borrower's promissory note to repay the loan. At the same time, the lender places a lien on the property for $5,000 as security for the debt. If the borrower defaults, the lien allows the lender to force the sale of the house to satisfy the debt. 2.9 D. An equitable interest. A lienor generally has an equitable interest in the property, but not legal ownership. The exception is a mortgage lien on a property in a title theory state. In these states, the mortgage transaction conveys legal title to the lender, who holds it until the mortgage obligations are satisfied. During the mortgage loan period, the borrower has equitable title to the property. 2.10 A. Payment of the debt that is the subject of the lien and recording of the satisfaction. A lien terminates on payment of the debt and recording of documents. Payment of the debt and recording of the appropriate satisfaction documents ordinarily terminate a lien. If a default occurs, a suit for judgment or foreclosure enforces the lien. These actions force the sale of the property. 2.11 d. Involuntary general lien. A general lien is one placed against any and all real and personal property owned by a particular debtor. An example is an inheritance tax lien placed against all property owned by the heir. A specific lien attaches to a single item of real or personal property and does not affect other property owned by the debtor. In addition, judgment liens are junior, involuntary liens. 2.12 a. Real estate tax lien. The category of superior, or senior, liens ranks above the category of inferior, or junior, liens, meaning that superior liens receive first payment from the proceeds of a foreclosure. The superior category includes liens for real estate tax, special assessments, and inheritance tax. Other liens, including income tax liens, mortgage liens, and judgment liens, are inferior. 2.13 d. Subordinate the lien. A liener can change the priority of a junior lien by voluntarily agreeing to subordinate, or lower, the lien's position in the hierarchy. This change is often necessary when working with a mortgage lender who will not originate a mortgage loan unless it is senior to all other junior liens on the property. The lender may require the borrower to obtain agreements from other lien holders to subordinate their liens to the new mortgage. 2.14 c. A proceeding to enforce a lien by forcing the sale or transfer of a secured property. All liens can be enforced by the sale or other transfer of title of the secured property, whether by court action, operation of law, or through powers granted in the original loan agreement. The enforcement proceedings are referred to as foreclosure. Note that lieners already possess equitable title, so they do not need to undertake a legal proceeding to establish this. 2.15 b. File a foreclosure suit. Judicial foreclosure occurs in states that use a two-party mortgage document, borrower and lender, that does not contain a power of sale provision. Lacking this provision, a lender must file a foreclosure suit and undertake a court proceeding to enforce the lien. 2.16 a. Strict foreclosure. Strict foreclosure is a court proceeding that gives the lender title directly, by court order, instead of giving cash proceeds from a public sale. On default, the lender gives the borrower official notice. After a prescribed period, the lender files suit in court, whereupon the court establishes a period within which the defaulting party must repay the amounts owed. If the defaulter does not repay the funds, the court orders transfer of full, legal title to the lender. 2.17 d. A license, which terminates upon the owner's death. A license is a personal right that a property owner grants to another to use the property for a specific purpose, to reach the kindergarten school bus. Unlike a personal easement in gross, which terminates only on the death of the grantee, Betty Lou Ann, in this instance, a license is revocable at any moment, is not. transferable and does not attach to the land. It ceases on the death of either party, or on the sale of the property. 2.18 d. Dominant tenement. An easement appurtenant gives a property owner a right of usage to portions of an adjoining property owned by another party. The property enjoying the usage right is called the dominant tenement, or dominant estate. The property containing the physical easement itself is the servient tenement, since it must serve the easement use. 2.19 b. A deed restriction. A private party who wants to control the quality and standards of a property can establish a deed restriction. Deed restrictions take precedence over zoning ordinances if they are more restrictive. 2.20 a. It involves a monetary claim against the value of a property. A lien is a creditor's claim against personal or real property as security for a debt of the property owner. If the owner defaults, the lien gives the creditor the right to force the sale of the property to satisfy the debt. Liens do not necessarily alter the property value. Liens can be involuntary as well as voluntary. Finally, liens attach to the property, but so do other encumbrances. 2.21 d. It is knowledge received or imparted through direct experience. The term notice is synonymous with knowledge. A person who has received actual notice has actual knowledge of something. Receiving actual notice means learning of something through direct experience or communication. Thus, a document in itself cannot be actual notice. It is the seeing of the document that makes it actual notice. 2.22 b. It is knowledge one could have or should have obtained. Constructive notice, or legal notice, is knowledge of a fact that a person could have or should have obtained. The foremost method of imparting constructive notice is by recordation of ownership documents in public records, specifically, title records. Since public records are open to everyone, the law generally presumes that when evidence of ownership is recorded, the public at large has received constructive notice of ownership. 2.23 a. Grant, deed, and will. Voluntary transfer, or voluntary alienation, is an unforced transfer of title by sale or gift from an owner to another party. If the transferor is a government entity and the recipient is a private party, the conveyance is a public grant. If the transferor is a private party, the conveyance is a private grant. A living owner makes a private grant by means of a deed of conveyance, or deed. A private grant that occurs when the owner dies is a transfer by will. 2.24 c. It gives constructive notice of ownership. Recording is not necessary to make a deed valid. However, it is in the grantee's best interests to do so. Recording the deed gives the public constructive notice of the grantee's ownership. 2.25 b. Granting clause. The granting, or premises, clause is the only required clause. It contains the conveyance intentions, names the parties, describes the property, and indicates a nominal consideration. 2.26 a. General warranty deed. The general warranty deed, or warranty deed for short, contains the fullest possible assurances of good title and protection for the grantee. The deed is technically a bargain and sale deed in which the grantor promises to defend against any and all claims to the title. The overall general warranty covenant is, I own and will defend. 2.27 d. To have an encumbrance removed if the lien holder cannot prove its validity. Where there is a possibility that prior errors in deeds or other recorded documents might cloud, encumber, the title, the relevant parties execute a quitclaim deed to convey any and all interest to the grantee. If a party responsible for encumbering title refuses to quitclaim the interest, the owner may file a quiet title suit. This requires the lienor to prove the validity of an interest. If the defendant is unable to do so, the court removes the cloud by decree. 2.28 a. A transfer tax based on the price of the property being conveyed. State law usually requires payment of a documentary stamp tax on a conveyance of real property. The tax is based on the actual price of the property conveyed, thus enabling taxing authorities to ascertain current market value for ad valorem tax purposes. Payment of the tax is evidenced on the deed. 2.29 b. Probate. A court proceeding called probate generally settles a decedent's estate, whether the person has died testate, having left a valid will, or inte state, having failed to do so. 2.30 a. It will escheat to the state or county. If an inte state decedent has no heirs, the estate escheats, or reverts, to the state or county after all claims and debts have been validated and settled. 2.31 d. Eminent domain. Various government and public entities can transfer private property to the public sphere by the power of eminent domain. The transfer is involuntary, even though the owner receives compensation. For example, a city government wants to widen a highway to accommodate growth. The government uses eminent domain to condemn and purchase all properties abutting the thoroughfare in order to complete the construction project. 2.32 a. Openly possessing and claiming the property without the owner's consent. To claim legal title, the adverse possessor must be able to show a claim of right or color of title as reason for the possession, have notorious possession, which is possession without concealment, maintain a consistent claim of hostile possession, which is a claim to ownership and possession regardless of the owner's claims or consent, occupy the property continuously for a statutory period of time, in some states, pay taxes. 2.33 c. The buyer. Title records protect the buyer by revealing whether a property has marketable title, one free of undesirable encumbrances. The buyer is legally responsible for knowing the condition of title, since it is a matter of public record. 2.34 a. A clouded title. Chain of title refers to the succession of property owners of record dating back to the original grant of title from the state to a private party. If there is a missing link in the chronology of owners, or if there was a defective conveyance, the chain is said to be broken, resulting in a clouded title to the property. 2.35 b. Standard Owner's Title Insurance Policy. An owner's policy may have standard coverage or extended coverage. Standard coverage protects against title defects such as incompetent grantors, invalid deeds, fraudulent transaction documents, and defects in the chain of title. Extended coverage protects against liabilities that may not be of public record, including fraud, unrecorded ownership claims, unintentional recording errors, and unrecorded liens. 2.36 A. Voluntary alienation. Voluntary alienation is an unforced transfer of title by sale or gift from an owner to another party. 2.37 D. A quitclaim deed. A quitclaim deed transfers real and potential interests in a property, whether an interest is known to exist or not. The grantor makes no claim to any interest in the property being conveyed and offers no warrants to protect the grantee. Where there is a possibility that prior errors in deeds or other recorded documents might cloud, encumber, the title, the relevant parties execute a quitclaim deed to convey any and all interest to the grantee. 2.38 A. Passed to the heirs by the laws of descent and distribution. In this circumstance, the estate, including real property, will pass to lawful heirs according to the state's laws of descent and succession or distribution. These laws apportion the estate without regard to the wishes of the heirs or the intentions of the decedent. Escheat, by which the state takes the property, applies only if there are no legal heirs. 2.39 D. Declined because possession was secretive. One of the preconditions for a claim of ownership based on adverse possession is notorious possession, or possession without concealment. Even if the length of possession in this case meets the statutory requirement, the drifter's secretiveness would invalidate the claim. 2.40 B. Free of undisclosed defects and encumbrances. Marketable title is, by definition, one that is free and clear of undesirable and unknown encumbrances, claims, clouds, or other defects. Attorneys' abstracts and title certificates do not guarantee that a title is marketable. 2.41 C. Estate at will. Three of the four principal types of leasehold estate are, the estate for years, which has a specific lease term, the estate from period to period, where the lease term of a specific period automatically renews, and the estate at will, which has no specified lease term. The fourth principal type, the estate at sufferance, is a tenancy without consent that therefore also has no specific term. 2.42 B. For specified reasonable purposes. A tenant has the sole right to occupy and use the premises without interference from outside parties, including the landlord. The landlord may enter the premises for specified purposes such as inspections, but the interference must be reasonable and limited. In addition, the landlord can do nothing outside of the lease's express provisions that would impair the tenant's enjoyment of income deriving from use of the premises. 2.43 A. Compliance with the rules and regulations of the building. The lease defines the tenant's obligations, which principally are to pay the rent on time, maintain the property's condition, and comply with the rules and regulations of the building. 2.44 B. providing required building support and services. The lease defines the landlord's obligations, which principally are to provide the necessary building support and services, and maintain the condition of the property. It is the tenant's responsibility to obtain insurance and to determine the fairness of the rent. 2.45 d. The tenant's estate is still obligated under the lease. A valid lease creates obligations that survive the death of the landlord or tenant, with certain exceptions. A tenant's estate remains liable for payment of rent if the tenant dies. The landlord's estate remains bound to provide occupancy despite the landlord's death. 2.46 a. The remaining tenant is responsible for the full rent obligation. Multiple tenants who sign a single lease are jointly and severally responsible for fulfilling lease obligations. Thus, if one renter abandons an apartment, the other renters remain liable for rent. 2.47 c. Sublease. Subletting, subleasing, is the transfer by a tenant, the sublessor, of a portion of the leasehold interest to another party, the sublessee, through the execution of a sublease. The sublease spells out all of the rights and obligations of the sublessor and sublessee, including the payment of rent to the sublessor. The sublessor remains primarily liable for the original lease with the landlord. The subtenant is liable only to the sublessor. 2.48 d. Net lease. A net lease requires a tenant to pay for utilities, internal repairs, and a proportionate share of taxes, insurance, and operating expenses in addition to rent. In effect, the landlord passes through actual property expenses to the tenant rather than charging a higher rent level. Net leases vary as to exactly what expenses the tenant is responsible for. The purest form of net lease requires tenants to cover all expenses, including major repairs and property taxes. 2.49 a. Gross lease. 2.49a. Gross lease, or full-service lease, requires the landlord to pay the property's operating expenses, including utilities, repairs, and maintenance, while the tenant pays only rent. Rent levels under a gross lease are higher than under a net lease, since the landlord recoups expense outlays in the form of added rent. 2.50 b. An owner-developer wants to retain ownership of the land portion of the improved real property. Ground leases are primarily used when an owner wishes to lease raw land to an agricultural or mining interest, when unimproved property is to be developed and the owner wants to retain ownership of the land, when the developer or future users of the property do not want to own the land, or when the owner of an improved property wishes to sell an interest in the improvements while retaining ownership of the underlying land. 2.51 a. Either party giving proper notice. In the absence of an explicit term with beginning and ending date, a court will generally construe the lease to be a tenancy at will, cancelable upon proper notice. 2.52 b. A tenancy from period to period. IRLTA sets standards for improving oral, vague, or unbalanced lease agreements. In the case of an unclear lease expiration date, the lease is generally deemed to be a periodic tenancy. 2.53 a. A hotel. State laws based on ERLTA generally do not apply to transient occupancies, such as hotel and motel rentals, proprietary leases in cooperatives, or to occupancy in a residence that is under a contract for deed. 2.54 c. A temporary possessory interest. A lease is both an instrument of conveyance and a contract between principal parties to uphold certain covenants and obligations. As a conveyance, a lease conveys an interest, called the leasehold estate, but does not convey legal title to the property. For this reason, a leasehold is also called a less than freehold estate. 2.55 d. A leased fee estate. In conveying the leasehold estate, the landlord acquires a leased fee estate, which entails the rights to receive rent, repossess the property following the lease term, and monitor the tenant's obligations to maintain the premises. 2.56 c. Occupy the property. The legal essence of a valid lease is that it conveys an exclusive right to use and occupy a property for a limited period of time in exchange for rent and the return of the property after the lease term is over. 2.57 a. The buyer acquires title subject to the lease, which remains in effect. The landlord may sell, assign, or mortgage the leased fee interest. However, transferring and encumbering the leased property do not extinguish the obligations and covenants of a lease. Buyers and creditors, therefore, must take their respective interests subject to the terms of the lease. 2.58 c. When either party gives proper notice. In the absence of an explicit term with beginning and ending date, a court will generally construe the lease to be a tenancy at will, cancelable upon proper notice. 2.59 c. A 5-year lease must be in writing to be enforceable. Generally, a lease for a period exceeding 1 year cannot be oral but must be in writing to be enforceable because of the statute of frauds. 2.60 b. The original tenant retains primary responsibility for performance of the original lease contract. In a sublease, a transfer of a portion of the leasehold, the sublessor, original tenant, remains primarily liable for the original lease with the landlord. The subtenant is liable only to the sublessor. National Test 3, Land Use Regulation and Control, Legal Descriptions, Contract Law 3.1, d. Zoning ordinances are a primary means of keeping land use in harmony with the master plan. The master plan fuses state and regional land use laws with local land use objectives that correspond to the municipality's social and economic conditions. The completed plan becomes the overall guideline for creating and enforcing zones, building codes, and development requirements. 3.2 c. Specify usage for every parcel within the zoning authority's jurisdiction. The intent of zoning ordinances is to specify land usage for every parcel within the jurisdiction. In some areas, state laws permit zoning ordinances to apply to areas immediately beyond the legal boundaries of the city or county. 3.3 b. To separate land uses so that they do not interfere with each other. One of the primary applications of zoning power is the separation of residential properties from commercial and industrial uses. Proper design of land use in this manner preserves the aesthetics and value of neighborhoods and promotes the success of commercial enterprises through intelligently located zones. 6 common types of zone are: residential, commercial, industrial, agricultural, public, and planned unit development, PUD. 3.4 C. The public interest. The principal forms of exceptions to a conforming use is legal non-conforming use, grandfathered in, variance based on hardship, and special exception based on the public interest. 3.5 D. The area of a commercial or industrial facility in relation to the size of the site. Commercial zoning regulates intensity of usage by limiting the area of store or office per site area. Intensity regulation is further achieved by minimum parking requirements, setbacks, and building height restrictions. 3.6 C. It requires that multiple tracts of land be developed according to a single design. Planned unit development zoning restricts use to development of whole tracts that are designed to use space efficiently and maximize open space. A PUD zone may be for residential, commercial, or industrial uses, or combinations thereof. 3.7 A. A homeowner in a residential zone converts her residence to a private school. A legal non-conforming use can be illustrated as follows. A motel is situated in a residential area that no longer allows commercial activity. The zoning board rules that the motel may continue to operate until it is sold, destroyed, or used for any other commercial purpose. An illegal non-conforming use is one that conflicts with ordinances that were in place before the use commenced. For instance, if the motel in the previous example is sold, and the new owner continues to operate the property as a motel, the motel is now an illegal, non-conforming use. 3.8 B. A variance is granted by the zoning board if the owner has a justifiable reason. A non-conforming use is one that clearly differs from current zoning and is subject to change upon conveyance. A zoning variance allows a use that differs from the applicable ordinance for a variety of justifiable reasons. 3.9 C. Certificate of occupancy. Building inspectors inspect a new development or improvement for code compliance. If the work complies, the municipality or county issues a certificate of occupancy which officially clears the property for occupation and use. 3.10 C. It conveys legal title to the acquiring entity. Eminent domain allows a government entity to purchase a fee, leasehold, or easement interest in privately owned real property for the public good, regardless of the owner's desire to sell or otherwise transfer any interest. In exchange for the interest, the government pays the owner a just compensation. To acquire a property, the public entity initiates a condemnation suit. Transfer of title extinguishes all existing leases, liens, and other encumbrances on the property. 3.11 D. Parties responsible for improper disposal of hazardous waste could be charged for the cleanup costs. Under CERCLA and the Superfund Amendment of 1986, current landowners as well as previous owners of a property may be held liable for environmental violations, even if innocent of a violation. Sellers often carry the greatest exposure, and real estate licensees may be held liable for improper disclosure. 3.12 A. Individual property rights and the public's interest. The optimum management of real property usage must take into account both the interests of the individual and the interests of the surrounding community. While maintaining the value of an individual estate is important, the owner of an estate must realize that unregulated use and development can jeopardize the value not only of the owner's estate but of neighboring properties. 3.13 C. Police power. At the local level, county and city governments control land use through the authority known as police power. The most common expressions of police power are county and municipal zoning. 3.14 D. The owner must sell the property in exchange for market value compensation. Eminent domain allows a government entity to purchase a fee, leasehold, or easement interest in privately owned real property for the public good, regardless of the owner's desire to sell or otherwise transfer any interest. In exchange for the interest, the government pays the owner a just compensation. 3.15 A. Reasonably promote community health, safety, and welfare. Local planners do not have unlimited authority to do whatever they want. Their zoning ordinances must be clear in import, apply to all parties equally, and promote health, safety, and welfare of the community in a reasonable manner. 3.16 D. To ensure that improvements comply with codes. Local governments enforce zoning ordinances by issuing building permits to those who want to improve, repair, or refurbish a property. To receive a permit, the project must comply with all relevant ordinances and codes. 3.17 B. To regulate the density of dwellings in the residential zone. Residential zoning regulates density, by limiting the number and size of dwelling units and lots in an area. 3.18 A. A special exception. A special exception grant authorizes a use that is not consistent with the zoning ordinance in a literal sense, yet is clearly beneficial or essential to the public welfare and does not materially impair other uses in the zone. 3.19 C. A legal nonconforming use. An illegal nonconforming use is one that conflicts with ordinances that were in place before the use commenced. For instance, if a motel that was allowed as a legal nonconforming use is sold, and the new owner continues to operate the property as a motel, the motel is now an illegal, nonconforming use. 3.20 B. A plat of subdivision. In addition to complying with zoning ordinances, a developer of multiple properties in a subdivision must meet requirements for subdivisions, including submission of a plat of subdivision. 3.21 A. Accurately identifies the boundaries of the property as distinct from all other properties. A legal description of real property is one which accurately locates and identifies the boundaries of the subject parcel to a degree acceptable by courts of law in the state where the property is located. The general criterion for a legal description is that it alone provides sufficient data for a surveyor to locate the parcel. A legal description identifies the property as unique and distinct from all other properties. 3.22 C. reference points, angles, and distances. A meets and bounds description identifies the boundaries of a parcel of real estate using reference points, distances, and angles. The description always identifies an enclosed area by starting at an origination point, called point of beginning, or POB, and returning to the POB at the end of the description. 3.23 b. Two consecutive common meridians. The vertical area between consecutive meridians is called a range. A range is identified by its relationship to the principal meridian. All ranges are 6 miles wide. 3.24 c. Two consecutive parallels. The horizontal area between two parallels is called a tier, or a township strip. A tier is identified by its relationship to the base parallel. All tiers are 6 miles wide. 3.25 b. 6 miles by 6 miles, or 6 miles square. A township is the area enclosed by the intersection of two consecutive meridians and two consecutive parallels. Since the parallels and meridians are 6 miles apart, a township is a square with 6 miles on each side. Its area is therefore 36 square miles. Remember to differentiate square miles from miles square. 4 square miles is a measure of area, 2 miles x 2 miles, 4 miles square is a representation of the sides of a square, 4 miles by 4 miles. 3.26 d. 1/64. The size in acres of a subsection of a township is a fraction of 640 acres, since there are 640 acres in a section. Thus 10 acres is 10/640, or 1/64 of a section. 3.27 d. Properties in a subdivision. The recorded plat method, also called the lot and block system, is used to describe properties in residential, commercial, and industrial subdivisions. Under this system, tracts of land are subdivided into lots. The entire group of lots comprises the subdivision. In a large subdivision, lots may be grouped together into blocks for ease of reference. 3.28 c. Meets and bounds. A meets and bounds description identifies the point of beginning and describes the distance and direction from that point to the first monument, and thence to subsequent monuments and back to the beginning to define the property's enclosed perimeter. 3.29 d. 36. The rectangular survey system divides a township into 36 sections. 3.30 a. 640. Each side of a section is 1 mile in length. Thus the area of a section is 1 square mile, or 640 acres. 3.31 c. Something of value traded in exchange for something of value. A contract must contain a two-way exchange of valuable consideration as compensation for performance by the other party. The contract is not valid or enforceable if just one party provides consideration. Valuable consideration may be something of tangible value, such as money, or something the party promises to do. It may also be something intangible that a party must give up. 3.32 a. Contain a legal description of the property. In addition to satisfying the requirements of a valid contract in general, a contract that conveys an interest in real estate must be in writing, contain a legal description of the property, and be signed by one or more of the parties. 3.33 d. A reasonable time, or until the expiration date on the offer. If an offer contains an expiration date and the phrase time is of the essence, the offer expires at exactly the time specified. In the absence of a stated time period, the offeree has a reasonable time to accept an offer. 3.34 b. The buyer's death terminated the offer. Any of the following actions or circumstances can terminate an offer: acceptance, rejection, revocation, lapse of time, counter-offer, or death or insanity of either party. 3.35 c. A contract for the sale of undeveloped land. A real estate contract that is not a personal contract for services can be assigned to another party unless the terms of the agreement specifically prohibit assignment. Listing agreements, for example, are not assignable, since they are personal service agreements between agent and principal. Sales contracts, however, are assignable, because they involve the purchase of real property rather than a personal service. 3.36 b. The parties act as if there is a contract. An implied contract is an unstated or unintentional agreement that may be deemed to exist when the actions of any of the parties suggest the existence of an agreement. 3.37 b. A sale contract before closing. An executory contract is one in which performance is yet to be completed. A sales contract prior to closing is executory. While the parties have agreed to buy and sell, the buyer has yet to pay the seller and the seller has yet to deed the property to the buyer. 3.38 a. Both parties promise to do something in exchange for the other party's performance. A bilateral contract is one in which both parties promise to perform their respective parts of an agreement in exchange for performance by the other party. An example of a bilateral contract is an exclusive listing. The broker promises to exercise due diligence in the efforts to sell a property, and the seller promises to compensate the broker when and if the property sells. 3.39 c. The broker may have a claim for marketing expenses expended during the listing term. The damaged party may elect the following legal remedies: rescission, forfeiture, suit for damages, or suit for specific performance. However, the broker must show that the seller has breached the contract. 3.40 d. The failure of a party to perform according to the terms of the contract. A breach of contract is a failure to perform according to the terms of the agreement. 3.41 b. The act of declaring that a contract is no longer in effect for a given party. Parties to a contract may rescind a contract by mutual consent, or a damaged party may rescind a contract unilaterally. This act of rescission cancels the contract and returns the parties to their pre-contract condition, including the refunding of any monies already transferred. 3.42 a. Reflect a mutual understanding or agreement. Mutual consent, also known as offer and acceptance and meeting of the minds, requires that a contract involve a clear and definite offer and an intentional, unqualified acceptance of the offer. 3.43 C. Unenforceable. A valid contract that is in writing is enforceable within a statutory time period. A valid contract that is made orally is also generally enforceable within a statutory period, with the exception that some contracts are enforceable only if they are in writing. These laws apply in particular to the transfer of interests in real estate. A void or voidable contract was not a truly valid contract. 3.44 B. Is possibly valid and enforceable. Incompetent parties, or parties of unsound mind, may not enter into enforceable contracts. However, during the period of one's incompetency, a court may appoint a guardian who may act on the incompetent party's behalf with court approval. 3.45 C. A counteroffer. By changing any of the terms of an offer, the offeree creates a counteroffer, and the original offer is void. At this point, the offeree becomes the offerer, and the new offeree gains the right of acceptance. If accepted, the counteroffer becomes a valid contract provided all other requirements are met. 3.46 D. Valuable consideration. Valuable consideration can be something of tangible value, such as money, or something a party promises to do or not do. For example, a home builder may promise to build a house for a party as consideration for receiving money from the home buyer. 3.47 C. Is void. The content, promise, or intent of a contract must be lawful. A contract that proposes an illegal act is void. 3.48 A. Must act within a statutory period. The statute of limitations restricts the time period for which an injured party in a contract has the right to rescind or disaffirm the contract. A party to a voidable contract must act within the statutory period. 3.49 B. Require certain conveyance-related contracts to be in writing. The Statute of Frauds requires that certain contracts must be in writing to be enforceable. Real estate contracts that convey an interest in real property fall in this category, with the exception that a lease of 1 year's duration or less may be oral. 3.50 B. The buyer has no obligations to the seller whatsoever. The mutual consent required for a valid contract is reached through the process of offer and acceptance. If the offeree accepts all terms without amendment, the offer becomes a contract. The exact point at which the offer becomes a contract is when the offeree gives the offerer notice of the acceptance. If an offer contains an expiration date and the phrase "time is of the essence," the offer expires at exactly the time specified. National Test 4, Agency, Listing Agreements 4.1, b. The laws of agency, or in some states, by statute. In every state, a body of law, generally called the law of agency, defines and regulates the legal roles of this relationship. While the relationship is subject to contract law, agency law dictates how the relationship will achieve its purposes, regardless of what the listing contract states. 4.2 c. The relationship is independent of any compensation arrangement. It is important to understand that the agency relationship does not require compensation or any form of consideration. Nor does compensation define an agency relationship. A party other than the principal may compensate the agent. 4.3 c. The defaulting party may have a financial consequence. Involuntary termination of the relationship may create legal and financial liability for a party who defaults or cancels. For example, a client may renounce an agreement but then be held liable for the agent's expenses or commission. 4.4 b. Present all offers to the principal regardless of their amount. A conventional listing agreement does not authorize an agent to obligate the client to contracts, and it does not allow the agent to conceal offers to buy, sell, or lease coming from a customer or another agent. Further, since a client relies on a broker's representations, a broker must exercise care not to offer advice outside of his or her field of expertise. 4.5 c. Confidentiality. The confidentiality standard is one of the duties that extends beyond the termination of the listing. At no time in the future may the agent disclose confidential information. 4.6 d. Comparable to that of other practitioners in the area. The agent is hired to do a job, and is therefore expected to do it with diligence and reasonable competence. Competence is generally defined as a standard of practice equal to the level of real estate marketing skills and knowledge of other practitioners in the area. 4.7 c. Disclose the information to the seller. An agent has the duty to inform the client of all material facts, reports, and rumors that might affect the client's interests in the property transaction. This includes the agent's opinion of the property's condition, information about the buyer's motivations and financial qualifications, discussions between agent and buyer regarding the possibility of the agents representing the buyer in another transaction. 4.8 a. The Andersons. Since Gary executed an agency agreement with the Andersons, they become the client and the Lincolns the customer, regardless of who pays the commission. 4.9 c. A broker who has an agency relationship with a client. In a subagency, a broker or licensed salesperson works as the agent of a broker who is the agent of a client. Subagents might include a cooperating licensed broker, that broker's licensed salespeople, and the listing broker's licensed salespeople, all of whom agree to work for the listing broker on behalf of the client. 4.10 b. One agent represents both sides in a transaction. Dual agency means representing both principal parties to a transaction. The agent represents both buyer and seller or tenant and owner. 4.11 c. Disclosing material facts that affect the value of the property to both parties. In the role of facilitator, the broker's only fiduciary duties and standards of conduct are those of accounting, skill, care, and diligence, honesty and fair dealing, and disclosure to both parties of all material facts in residential sale transactions affecting the property's value. Some states do not allow for this form of relationship in a real estate transaction. 4.12 A. The agent is showing the client's property to a prospective buyer. Agency disclosure must occur upon substantive contact between the listing agent and a customer. Examples of substantive contact include showing the prospect a property, eliciting confidential information from a prospect regarding needs, motivation, or financial qualification, and executing a contractual offer to sell or lease. 4.13 D. Trust, confidence, and good faith. The essence of the agency relationship is trust, confidence, and mutual good faith. The principal trusts the agent to exercise the utmost skill and care in fulfilling the authorized activity, and to promote the principal's best interests. The agent undertakes to strive in good faith to achieve the desired objective, and to fulfill the fiduciary duties. 4.14 B. General. In a general agency, the principal delegates to the agent ongoing tasks and duties within a particular business or enterprise. Such delegation may include the authority to enter into contracts. 4.15 B. Special. Under a special agency agreement, the principal delegates authority to conduct a specific activity, after which the agency relationship terminates. In most cases, the special agent may not bind the principal to a contract. Real estate brokerage is commonly based on a special agency. 4.16 C. A party creates an agency relationship outside of an express agreement. An agency relationship can arise by implication, intentionally or unintentionally. Implication means that the parties act as if there were an agreement. For example, if an agent promises a buyer to do everything possible to find a property at the lowest possible price, and the buyer accepts the proposition, there may be an implied agency relationship even though there is no specific agreement. 4.17 A. Condemnation of the property. An agency relationship may terminate contrary to the wishes of the parties by reason of death or incapacity of either party, abandonment by the agent, condemnation or destruction of the property, renunciation, breach, bankruptcy, or revocation of the agent's license. 4.18 A. The agent has violated the duty of confidentiality. An agent may not disclose any information that would harm the client's interests or bargaining position, or anything else the client wishes to keep secret. The confidentiality standard is one of the duties that extends beyond the termination of the listing. At no time in the future may the agent disclose confidential information. 4.19 B. The agent has not violated fiduciary duty. Since it is illegal to refuse to show buyers the property based on where the buyers live, the agent has not violated fiduciary duty. The duty of obedience only applies to legal activities. 4.20 D. Inform the seller. An agent has the duty to inform the client of all material facts, reports, and rumors that might affect the client's interests in the property transaction. 4.21 A. Prior to completing a listing agreement. An agent who intends to represent a seller or owner must disclose the import of the proposed agency relationship in writing before the listing agreement is executed. 4.22 C. Whenever substantive communication is made beyond casual conversation, a listing agent must disclose in writing to a buyer or tenant that the agent represents the owner in the transaction. This disclosure must occur before or at the first substantive contact with the customer prospect. In some states, buyer representatives must disclose the agency relationship to sellers or their agents upon initial contact. 4.23 B. Upon initial contact, a buyer agent must disclose the agency relationship to the seller or seller's agent on first contact. Substantive contact is assumed to occur immediately in this circumstance. 4.24 A. May not represent one party's interests to the detriment of the other. A dual agent's first duty is to disclose the agency relationship to both principal parties or to withdraw from one side of the duality. After disclosing, the agent must obtain the written consent of both parties. If both parties accept the dual agency, the agent owes all the fiduciary duties to both parties except full disclosure, undivided loyalty, and exclusive representation of one principal's interests. 4.25 D. Practicing law without a license. An agent should not act or speak outside the agent's area of expertise. A customer may rely on anything an agent says, and the agent will be held accountable. For example, an agent represents that a property will appreciate. The buyer interprets this as expert investment advice and buys the property. If the property does not appreciate, the buyer may hold the agent liable. 4.26 A. Fiduciary and contractual obligations with the client. A listing agreement establishes an agency relationship between agent and client that commits the agent to the full complement of fiduciary duties to the client in fulfilling the agreement. 4.27 D. Market, sell and show the property. Special agency limits the scope of the broker's authority to specific activities, generally those which generate customers and catalyze the transaction. A special agency agreement usually does not authorize a broker to obligate the client to a contract as a principal party. Normally, principals do not delegate the authority to negotiate price to an agent in a residential transaction. 4.28 B. An implied agency may have been created, with obligations to perform for both seller and agent. Clients and agents may also create an implied agency listing based on substantive actions rather than on an express agreement. For example, if a seller allows a broker to undertake certain activities toward effecting a transaction without a specific authorization, but with full knowledge and consent, an implied agency may have been created. 4.29 A. The agent cannot assign the listing agreement. Since a listing agreement is a personal service contract, it is not assignable. In particular, a broker cannot assign a listing to another broker. 4.30 B. Exclusive right to sell. The exclusive right to sell listing, or exclusive, gives the agent the most control over the property and the greatest likelihood of being compensated for his or her marketing efforts. 4.31 C. A listing that is entered in a multiple listing service to enable cooperation with member brokers. Though not a distinct type of listing agreement, multiple listing is a significant feature of brokerage practice. Multiple listing is an authorization to enter a listing in a multiple listing service. 4.32 B. The customer must be legally competent to undertake the transaction. Effecting a completed transaction means finding a customer who is not only ready, willing, and able, but one who makes an acceptable offer. A ready, willing, and able customer is one who is amenable to the terms of the transaction, ready and willing, and is financially capable of paying the price and legally capable of completing the transaction, able. 4.33 A. Obtain and distribute compensation. In the normal course of business, a listing broker delegates marketing responsibilities to salespeople. A salesperson may not, however, seek compensation directly from a client. Only the broker can obtain and disperse the compensation. 4.34 C. Parry, since he found the customer. The two principal determinants of procuring cause are being first to find the customer, and being the one who induces the customer to complete the transaction. 4.35 D. It may be terminated against the agent's will. A listing may terminate on grounds of performance, infeasibility, mutual agreement, revocation, abandonment, breach, lapse of time, invalidity of the contract, incapacitation of either party, destruction of the property, or, in this case, involuntary title transfer. 4.36 B. Sue the broker for money damages. If the broker cancels the listing or otherwise defaults, the client may sue the broker for money damages. 4.37 B. Exclusive agency agreement. An exclusive agency listing authorizes a single broker to sell the property and earn a commission, but leaves the owner the right to sell the property without the broker's assistance, in which case no commission is owed. 4.38 C. Open listing. An open listing is a non-exclusive authorization to sell or lease a property. The owner may offer such agreements to any number of brokers in the marketplace. With an open listing, the broker who is the first to perform under the terms of the listing is the sole party entitled to a commission. 4.39 D. Net listing. A net listing is one in which an owner sets a minimum acceptable amount to be received from the transaction and allows the broker to have any amount received in excess as a commission, assuming the broker has earned a commission according to the other terms of the agreement. 4.40 A. The client. Generally, buyer and tenant representation agreements are subject to the same laws and regulations as those applying to owner listings. The only difference is the client and his or her transaction expectations. 4.41 A. To list the owner's property in a multiple listing service. A multiple listing is not a distinct listing contract but rather a provision in an exclusive listing authorizing the broker to place the listing into a multiple listing service. A multiple listing service is an organization of member brokers who agree to cooperate in the sale of properties listed by other brokers in exchange for a share of the broker's resulting commission. National Test 5, Brokerage Business, Sale Contracts 5.1, d. Nonprofit Corporation. A nonprofit corporation is a corporate entity which is not legally entitled to generate profit. A nonprofit organization may not broker real estate. 5.2, c. Are properly licensed. A joint venture is a partnership formed to complete a specific business endeavor, such as a real estate development. Individuals, general and limited partnerships, and corporations may participate. A joint venture may broker real estate, provided the co-venturers are duly licensed. 5.3, b. A single employing broker who has an active broker's license. Only a broker with an active broker's license can hire and employ a licensed salesperson. A licensed salesperson may work only for the employing broker and may not work for or receive direct compensation from any other broker. 5.4, c. Offer a property for lease on behalf of the employing broker. A sales agent is only authorized to represent a broker and carry out such duties as the broker may legitimately delegate. Thus, a sales agent does not directly represent the client in a transaction but is rather the agent of the broker and subagent of the client. 5.5, d. The employing broker. Agents can only receive compensation from their employing brokers. Co-op commissions, referral fees, and other compensations always flow through the broker to the sales agent. 5.6, d. $4,940. First calculate the total commission, then the co-brokerage splits, then the agent-broker split. Thus, $380,000 x 6.5% equals $24,700 total commission. $24,700 x 50% equals $12,350 total listing broker share. $12,350 x 40% equals $4,940 agent's share. 5.7, c. $4,278. The total commission is $245,000 x 3%, equals $7,350. The agent gets 65% x $7,350, $500, which equals $4,278. 5.8, c. Complete the signing of the listing. Once the seller signs the listing, the next critical task is to get it signed, thereby making the listing a contract. Some states allow a salesperson to do this, and in other states, the listing must be given to the broker for signing. This result will set in motion the process of marketing the property. The agency disclosures must take place prior to the execution of the agreement. 5.9, b. Present the offer to the seller at the earliest possible moment. When a buyer or tenant makes an offer, the agent must present it to the seller or landlord at the earliest possible moment. If the terms of the offer are unacceptable, the agent may assist the seller in developing a counter-offer. 5.10 C. The broker has illegally converted security funds for business use. Conversion is the act of misappropriating escrow funds for the broker's business or personal use. Conversion carries serious consequences, including license revocation. 5.11 D. Never. All advertising must reveal the identity of the broker. Licensed brokers and agents may not use blind ads that conceal their identities. 5.12 A. Fair trade and antitrust laws. Brokerage companies, like other businesses, are subject to antitrust laws designed to prevent monopolies and unfair trade practices. In real estate brokerage, the primary manifestations of unfair trade practice are collusion, price fixing and market allocation. In this instance, the brokers are price fixing. 5.13 B. Outside brokers assist a listing agent in procuring a buyer. Most listing agreements provide for brokerage cooperation in the multiple listing clause. A transaction involving a cooperating subagent is called co-brokerage. In a co-brokered transaction, the listing broker splits the commission with the co-broker, typically on a 50-50 basis. 5.14 D. Only members of the National Association of Realtors registered. The term realtor registered is a protected trade name of the National Association of Realtors registered. Only members of this organization may use the term to refer to themselves. 5.15 A. Represent their employing broker in procuring clients and customers. Agents may only act on behalf of their broker. They may not assume responsibilities for other listings since listings are not transferable. 5.16 A. The IC is responsible for his or her own taxes, the broker does not withhold. Generally, a broker has limited control over the actions of a contractor. Specifically, a broker can require performance results, but is limited in demanding how a contractor performs the work, and the broker does not take responsibility for a contractor's income and social security taxes. 5.17 B. Competitive conditions. Commission structures are negotiated between the agent and employing broker as a function of competitive market conditions. 5.18 C. Avoid disclosing what price the owner will accept. An agent must be extremely careful at this point to abide by fiduciary obligations to the client, whoever that party may be. Discussions of price are particularly delicate. Whether the client is buyer or seller, the agent's duty is to uphold the client's best interests. Thus, it is not acceptable to suggest to a customer what price the client will or will not accept. 5.19 D. Mixing escrow funds with the broker's operating funds. Commingling, a prohibited activity, is the act of mixing the broker's personal or business funds with escrow funds. 5.20 A. There is insufficient evidence of anything other than a normal business practice. Charging identical commission rates in itself is legitimate. Price fixing occurs when competitors have in fact colluded together to set prices. 5.21 C. All the obligations and promises are performed and the transaction is closed. An executory contract is one for which the signatories have yet to perform their respective obligations and promises. Upon closing, the sale contract is fully performed and no longer exists as a binding agreement. 5.22 A. Use a standard contract promulgated by a state agency or a real estate board. It is advisable, and legally required in most states, for a broker to use a standard contract form promulgated by state agencies or real estate boards, as such forms contain generally accepted language. This relieves the broker of the dangers of creating new contract language, which can be construed as a practice of law for which the broker is not licensed. 5.23 B. Be written. A contract for the sale of real estate is enforceable only if it is in writing. A buyer or seller cannot sue to force the other to comply with an oral contract for sale, even if the contract is valid. 5.24 A. The contract has been legitimately cancelled and is null and void. To be valid, a contract must meet the criteria of competent parties, voluntary act of good faith, mutual consent, legal purpose, and valuable consideration. The buyer broke the mutual consent requirement by opting out before being told of the seller's acceptance. Thus, there is no valid contract. 5.25 C. An offer and acceptance. A contract of sale is created by full and unequivocal acceptance of an offer. Offer and acceptance satisfy the mutual consent requirement for a valid contract. The offeree must accept the offer without making any changes whatsoever. 5.26 D. Equitable title. A sale contract gives the buyer an interest in the property that is called equitable title, or ownership in equity. If the seller defaults and the buyer can show good faith performance, the buyer can sue for specific performance, that is, to compel the seller to transfer legal title upon payment of the contract price. 5.27 B. A condition that, if unmet, renders the contract unenforceable. A contingency is a condition that must be met before the contract is enforceable. If one party cannot meet a contingency condition by a specified deadline, the other party may cancel the contract. 5.28 C. The buyer may be able to have the contract cancelled. The termite inspection clause is a contingency clause. If one party cannot meet a contingency condition by a specified deadline, the other party may cancel the contract. Did the clause state that the inspector had to be properly licensed? If so, the buyer has a good case for cancellation. 5.29 A. Until the seller communicates acceptance of the offer. An offeror may revoke an offer for any reason prior to communication of acceptance by the offeree. 5.30 B. Fred has entered into contracts with both Jack and Sally to sell the same property. Jack's acceptance of Fred's offer creates a valid contract, just as Fred's acceptance of Sally's offer creates a valid contract. Fred should have revoked his offer to Jack before accepting Sally's offer. 5.31 D. Agency relationships and property condition. It is common for the seller to disclose the property condition requiring the buyer to acknowledge receipt of the disclosure. The broker discloses the applicable agency relationships in the transaction and names the party who must pay the brokerage commission. 5.32 B. Valuable consideration and a right to buy. An option to buy is an enforceable contract in which a potential seller, the optioner, grants a potential buyer, the optionee, the right to purchase a property before a stated time for a stated price and terms. In exchange for the right of option, the optionee pays the optioner valuable consideration. 5.33 A. Schmidt must sell to Carboy for $10,000. Mary's option to buy contract is enforceable, assuming she paid a consideration for it. 5.34 D. It is always assignable unless the contract prohibits assignment. A real estate contract that is not a personal service contract can be assigned to another party unless the terms of the agreement specifically prohibit assignment. An option to buy is therefore assignable in the absence of such a prohibiting clause. 5.35 C. At the end of the contract period, the vendor conveys legal title, provided the vendee has fulfilled all obligations. A contract for deed is a bilateral agreement between a seller, the vendor, and a buyer, the vendee, in which the vendor defers receipt of some or all of the purchase price of a property over a specified period of time. At the end of the period, the buyer completes payment to the vendor of the full purchase price and the vendor deeds legal title to the vendee. 5.36 B. The parties have completed a verbal, executory contract. As a sale contract created by an offer and acceptance, the parties have an executory contract. The parties have yet to perform their respective obligations and promises. However, as a contract for the sale of real estate, this verbal contract is not enforceable. An enforceable real estate sale contract must be in writing. 5.37 C. The assignor has completed a legal action. Either party to a sale transaction can assign the sale contract to another party, subject to the provisions and conditions contained in the agreement. 5.38 D. Any conveyance may trigger an acceleration of any loan secured by the property. The mortgage agreement may or may not state that the seller's loan will be accelerated by the lender and called due on sale. The due on sale clause in the sale contract merely stipulates that the buyer and seller recognize the possibility that loans that survive the closing may be called due. 5.39 D. The option is expired, and the tenant has no rightful claim to money paid for the option. The option automatically expires at the end of the option period. The landlord has no obligation, either to sell the property or to return the consideration, after the expiration date. 5.40 C. The seller retains legal title while the buyer makes partial payments until the contract is fully executed. In a contract for deed, the seller, or vendor, defers receipt of some or all of the purchase price of a property over a specified period of time. During the period, the vendor retains legal title and the vendee acquires equitable title. At the end of the period, the buyer pays the vendor the full purchase price and the vendor deeds legal title to the vendee. National Test 6, Economics, Appraisal 6.1, b. Demand for the item is increasing in relation to supply of the item. In a market economy, the primary interactions between supply, demand, and price are, if supply increases relative to demand, price decreases; if supply decreases relative to demand, price increases; if demand increases relative to supply, price increases; and if demand decreases relative to supply, price decreases. 6.2 d. Supply and demand are equal, and price and value are equal. A market tends toward a state of equilibrium in which supply equals demand, and price, cost, and value are identical. According to this principle, market demand moves to meet supply, and supply moves to meet demand. If there is an extreme shortage of an item for which there is normally a strong demand, suppliers will rush to increase production to close the gap. If inventories of an item are very high, suppliers will stop production until the oversupply has been depleted. 6.3 c. The uniqueness of every parcel. In comparison with other economic products and services, real estate has certain unique traits. Traits of real estate include inherent product value, uniqueness of every property, demand must come to the supply, illiquidity, slow to respond to changes, and a decentralized local market. 6.4 d. Prices rise. If demand is increasing and a moratorium slows supply, demand will begin to outpace supply, forcing prices to rise as the product becomes scarcer in relation to demand. 6.5 b. An increase in demand for all types of real estate. New businesses will arise to support the new company. They will hire new employees, some from out of town. The new employees will need housing. Hence the demand for residential real estate, as well as for commercial and industrial, will intensify, and it will also stimulate new construction. 6.6 d. The number of available units that become occupied over a period of time. Absorption is the amount of available property that becomes occupied over a period of time. 6.7 a. Rising prices. Within the business cycle of real estate, declining vacancy indicates a combination of increasing demand which fills up supply which in turn decreases. As space becomes scarcer, rents for available space increase. 6.8 b. Desire, utility, scarcity, and purchasing power. The value of something is based on the answers to 4 questions. How much do I desire it? How useful is it? How scarce is it? And am I able to pay for it? 6.9 b. Will increase. If there is no longer a supply to meet the increasing demand of a growing population, prices for existing supply will rise. 6.10 d. The market tending toward equilibrium. A market tends toward a state of equilibrium in which supply equals demand, and price, cost, and value are identical. Thus, if supply is scarce, construction will increase to stabilize the imbalance. 6.11 C. The market is oversupplied. Falling prices indicate an oversupply of commercial properties in relation to demand. In this case, construction of new supply will also slow down. 6.12 A. Have been increasing. A rise in prices is a market signal that there is an undersupply of product in relation to demand. As the market moves toward equilibrium, builders construct more buildings to meet the unmet demand. 6.13 C. It is often difficult to convert to cash. Since real estate is often a large, long-term investment that has no exact duplicate, the process of a buyer's evaluating and choosing the right property is long and complex. Hence, finding a buyer at a desired price can take a long time. 6.14 B. The number of persons employed in base industries in an area. Base employment is the number of persons employed in the base industries that represent the economic foundation of an area. It is the driving component of total employment, which includes secondary and support industries, and which creates demand for all types of real estate. 6.15 D. The total existing space of a certain type that is unoccupied at a given time. Vacancy is the amount of total real estate inventory of a certain type that is unoccupied at a given time. It is often stated as a percentage of total inventory, the vacancy rate for that property type. 6.16 A. Local government influencing the real estate market, regardless of demand. Local governments sometimes declare a moratorium on new construction because of present or projected inadequacies of the infrastructure, water, sewer, power, roads, etc., or because of the desire to conform to a master plan. The result may be to drive up prices, as supply cannot freely increase to meet demand. 6.17 C. In and out migrations of major employers. Changes in employment numbers in a local market area, especially in major industries, have a direct impact on real estate demand in the area. Money supply, interest rates, and trade imbalances also have an impact, but they are regional or national factors rather than strictly local. 6.18 B. Vacancy rises and prices fall. New construction generally occurs to meet an excess of demand. By adding supply, it tends to increase vacancy and lower prices until supply-demand equilibrium is achieved. 6.19 D. Residential. While all types of users may have these needs, they are most prominent for residential users because of concerns for family comfort and safety. Retail users are more concerned with competitive features of the trade area. Office users care more about occupancy costs and suitability for the business. Industrial users care more about such features as functionality, accessibility, and the labor pool. 6.20 C. Its susceptibility to swings in the local economy. Because a real property cannot be transferred to a large, central real estate marketplace, its marketability is closely tied to local conditions. Investors and users must come to the product, unlike other types of economic product that can be moved to a place in search of greater demand. 6.21 b. Anticipation. Anticipation is the value principle that a buyer will pay a price based on the benefits the buyer expects to derive from a property over a holding period. For example, if an investor anticipates an annual rental income from a leased property to be $1 million, this expected sum has a direct bearing on what the investor will pay for the property. 6.22 b. A homeowner adds a third bathroom to a house and thereby increases the appraised value by $10,000. The principle of contribution focuses on the degree to which a particular improvement affects market value of the overall property. In essence, the contribution of the improvement is equal to the change in market value that the addition of the improvement causes. For example, adding a bathroom to a house may contribute an additional $15,000 to the appraised value. Thus the contribution of the bathroom is $15,000. 6.23 a. Assemblage. Assemblage, or the conjoining of adjacent properties, sometimes creates a combined value that is greater than the values of the unassembled properties. The excess value created by assemblage is called plottage value. 6.24 d. Market value is an estimate. Market price is the price at which a property sold. Market value is an estimate of the price at which a property will sell at a particular time. The market price, as opposed to market value, is what a property actually sells for. Market price should theoretically be the same as market value if all the conditions essential for market value are present. Market price, however, may not reflect the analysis of comparables and of investment value that an estimate of market value includes. 6.25 d. Define the appraisal problem and the purpose of the appraisal. The first step in the process is to define the appraisal problem and the purpose of the appraisal. This involves identifying the subject property by legal description, specifying the interest to be appraised, specifying the purpose of the appraisal, specifying the date for which the appraisal is valid, and identifying the type of value to be estimated. 6.26 c. Weighing the applicability of the approaches and considering the quality of data supporting each approach. The final step in the appraisal process is to reconcile the value estimates produced by the three approaches to value into a final value estimate. To do this, an appraiser must weigh the appropriateness of a particular approach to the type of property being appraised and take into account the quality and quantity of data obtained in each method. 6.27 b. Make dollar adjustments to the sale prices of comparable properties to account for competitive differences with the subject. The sales comparison approach consists of comparing sale prices of recently sold properties that are comparable with the subject, and making dollar adjustments to the price of each comparable to account for competitive differences with the subject. After identifying the adjusted value of each comparable, the appraiser weights the reliability of each comparable and the factors underlying how the adjustments were made. The weighting yields a final value range based on the most reliable factors in the analysis. 6.28 d. takes into account the competitive value of specific amenities of the subject property. The sales comparison approach is widely used because it takes into account the subject property's specific amenities in relation to competing properties. In addition, because of the currency of its data, the approach incorporates present market realities. 6.29 A. Adds value to a comparable that is inferior to the subject property. If the comparable is inferior to the subject in some characteristic, an amount is added to the price of the comparable. If the comparable is better than the subject in some characteristic, an amount is deducted from the sale price of the comparable. This neutralizes the comparable's competitive advantage or disadvantage in an adjustment category. For example, a comparable has a swimming pool and the subject does not. To equalize the difference, the appraiser deducts an amount, say $6,000, from the sale price of the comparable. 6.30 B. Requires the fewest and smallest adjustments. As a rule, the fewer the total number of adjustments, the smaller the adjustment amounts, and the less the total adjustment amount, the more reliable the comparable. 6.31 C. $195,000. Since the comparable has an extra bath, it is adjusted downward to equalize with the subject. Conversely, since it has no patio, the appraiser adds value to the comparable. Thus, $200,000 minus $7,000 plus $2,000 equals $195,000. 6.32 D. Add the estimated land value and cost of improvements and subtract the accrued depreciation of the improvements. The cost approach consists of estimating the value of the land as if vacant, estimating the cost of improvements, estimating and deducting accrued depreciation, and adding the estimated land value to the estimated depreciated cost of the improvements. 6.33 B. Is very accurate for a property with new improvements that represent the highest and best use. The strengths of the cost approach are that it provides an upper limit for the subject's value based on the undepreciated cost of reproducing the improvements. It is also very accurate for valuing a property with new improvements which are the highest and best use of the property. 6.34 C. A property loses the same increment of value each year over the economic life of the property. All property improvements have an economic life, which becomes incrementally shorter year after year as physical deterioration takes its toll. The property as a whole does not lose value, since land itself does not depreciate. Similarly, an improvement can regain value if it is repaired or updated. Finally, not all properties lose value from economic obsolescence. 6.35 D. $115,000. To appraise value using the cost approach, add the land value to the value of the depreciated improvement. Thus you have $30,000 plus $95,000 to $10,000, or $115,000. 6.36 B. Divide the income a property generates by a rate of return. An appraiser obtains an indication of value from the income capitalization method by dividing the estimated net operating income for the subject by the rate of return, or capitalization rate. The formula is NOI/cap rate equals value. 6.37 C uses a method that is also used by investors to determine how much they should pay for an investment property. The strength of the income approach is that it is used by investors themselves to determine how much they should pay for a property. Thus, in the right circumstances, it provides a good basis for estimating market value. The approach, however, does not project what an income property's future income will be. Moreover, it is not an applicable method for estimating value if the subject is a non-income producing property. 6.38 A. $370,000. First, identify net income by subtracting out vacancy and expenses. Then divide by the capitalization rate. Thus, $60,000 to $3,000, $20,000, divided by 10% equals $370,000. 6.39 D. 150. The monthly gross rent multiplier for a property is equal to the price divided by the monthly rent. Thus, $450,000 divided by $3,000 equals 150. 6.40 C. $203,000. Multiply the monthly gross income times 12 to derive annual income. Multiply annual income times the gross income multiplier to derive the estimate of price. Thus, $1,200 times 12 equals $14,400. This times 14.1 equals $203,040, or $203,000 rounded. 6.41 C. The state in which the appraiser operates. A state-certified appraiser is one who has passed the necessary examinations and competency standards as established by each state in conformance with the federal standards. 6.42 A. The Financial Institutions Reform, Recovery, and Enforcement Act, FIRREA. Title 11 of FIRREA requires that competent individuals whose professional conduct is properly supervised perform all appraisals used in federally related transactions. As of January 1, 1993, such federally related appraisals must be performed only by state-certified appraisers. 6.43 A. If two similar properties are for sale, a buyer will purchase the cheaper of the two. According to the principle of substitution, a buyer will pay no more for a property than the buyer would have to pay for an equally desirable and available substitute property. For example, if three houses for sale are essentially similar in size, quality, and location, a potential buyer is unlikely to choose the one that is priced significantly higher than the other two. 6.44 A. Is physically and financially feasible, legal, and the most productive. This valuation principle holds that there is, theoretically, a single use for a property that produces the greatest income and return. A property achieves its maximum value when it is put to this use. The use must, however, be legal. 6.45 d. $200,000. Market value is an opinion of the price that a willing seller and willing buyer would probably agree on for a property at a given time. If the transaction is for cash, the property is exposed on the open market for a reasonable period. Buyer and seller have full information about market conditions. There is no abnormal pressure on either party. It is an arm's length transaction. Title is marketable, and the price does not include hidden influences such as special financing deals. The amount Lynn actually paid is the market price. The previous listing price and Ken's offer might be interesting data for the appraiser, but the appraisal must also consider other market data, such as comparable sales. 6.46 a. There may be no recent sale price data in the market. The sales comparison approach is limited in that every property is unique. As a result, it is difficult to find good comparables, especially for special purpose properties. In addition, the market must be active, otherwise, sale prices lack currency and reliability. 6.47 c. Selects comparable properties, adjusts the comparables, and estimates the value. The steps are to first identify comparable sales, then compare comparables to the subject and make adjustments to comparables, then, finally, weigh values indicated by adjusted comparables for the final value estimate of the subject. 6.48 b. The seller offers below-market seller financing. The principal factors for comparison and adjustment are time of sale, location, physical characteristics, and transaction characteristics. An adjustment may be made for such differences as mortgage loan terms, mortgage assumability, and owner financing. 6.49 b. Weights the comparables. The last step in the approach is to perform a weighted analysis of the indicated values of each comparable. The appraiser, in other words, must identify which comparable values are more indicative of the subject and which are less indicative. However, all comparables are taken into account, not simply the nearest comparable. 6.50 b. Market value is not always the same as what the property cost. The limitations of the cost approach are that, the cost to create improvements is not necessarily the same as market value, and depreciation is difficult to measure, especially for older buildings. 6.51 b. Replacement cost. Reproduction cost is the cost of constructing, at current prices, a precise duplicate of the subject improvements. Replacement cost is the cost of constructing, at current prices and using current materials and methods, a functional equivalent of the subject improvements. 6.52 d. Functional obsolescence. Functional obsolescence occurs when a property has outmoded physical or design features which are no longer desirable or acceptable to current users. 6.53 b. Incurable economic obsolescence. Economic, or external, obsolescence is the loss of value due to adverse changes in the surroundings of the subject property that make the subject less desirable. Since such changes are usually beyond the control of the property owner, economic obsolescence is considered an incurable value loss. 6.54 C. Depreciation. Depreciation is the loss of value in an improvement over time. The loss of an improvement's value can come from any cause, such as deterioration, obsolescence, or changes in the neighborhood. 6.55 A. Estimates depreciation, subtracts depreciation from cost, and adds back the land value. The steps in the costs approach are: 1. Estimate land value, 2. Estimate reproduction or replacement cost of improvements, 3. Estimate accrued depreciation, 4. Subtract accrued depreciation from reproduction or replacement cost, and 5. Add land value to depreciated reproduction or replacement cost. National Test 7, Finance 7.1, B. A state in which a mortgagee has equitable title to a secured property. States differ in their interpretation of who owns mortgaged property. Those that regard the mortgage as a lien held by the mortgagee, lender, against the property owned by the mortgager, borrower, are called lien theory states. Those that regard the mortgage document as a conveyance of ownership from the mortgager to the mortgagee are called title theory states. 7.2 D. It is evidence of the borrower's debt to the lender. A valid mortgage or trust deed financing arrangement requires a note as evidence of the debt. 7.3 A. Trust deed or mortgage. The mortgage or trust deed is evidence of the collateral pledge of the purchased property as security for the loan. 7.4 B. Mortgager. The mortgager is the borrower and the mortgagee is the lender. As a memory aid, notice that lender and mortgagee both have two ES. Mortgager and borrower both have two OS. 7.5 D. $1,000. Multiply the rate times the loan amount and divide by 12 to calculate monthly interest. Thus, $200,000 x 6%, divided by 12 equals $1,000. 7.6 B. $100,000. The equation for the loan amount is annual interest divided by the interest rate, equals loan amount. Thus, $500 x 12, divided by 0.06 equals $100,000. 7.7 A. 7.5%. The equation for the interest rate is annual payment / loan amount, equals interest rate. Thus, $3,750 / $50,000, equals 7.5%. 7.8 B. $2,000. A discount point is 1% of the loan amount. Thus, 1 point on a $100,000 loan equals $100,000 x 2%, or $100,000 x 0.02, or $2,000. 7.9 B. Part of each periodic payment is applied to repayment of the loan balance in advance and part is applied to payment of interest in arrears. In an amortizing loan, part of the principal is repaid periodically along with interest, so that the principal balance decreases over the life of the loan. The annual interest is never the same, since the principal balance to which the interest rate applies changes every year. Interest on a loan is always paid in arrears, not in advance. 7.10 B. Private mortgage insurance. Mortgage insurance protects the lender against loss of a portion of the loan, typically 20 to 25%, in case of borrower default. Private mortgage insurance generally applies to loans that are not backed by the Federal Housing Administration, FHA, or Veterans Administration, VA, and that have a down payment of less than 20% of the property value. The FHA has its own insurance requirement for loans with a down payment of less than 20%. 7.11 D. The fraction of the appraised value of the property offered as collateral which the lender is willing to lend. The relationship of the loan amount to the property value, expressed as a percentage, is called the loan-to-value ratio, or LTV. If the lender's loan-to-value ratio is 80%, the lender will lend only $80,000 on a home appraised at $100,000. The difference between what the lender will lend and what the borrower must pay for the property is the amount the borrower must provide in cash as a down payment. 7.12 C. Buyer's down payment. Price-less loan is the down payment. This is also the buyer's initial equity. 7.13 A. Refusing a loan because the borrower does not match the lender's target market. The Equal Credit Opportunity Act, ECOA, requires a lender to evaluate a loan applicant on the basis of that applicant's own income and credit rating, unless the applicant requests the inclusion of another's income and credit rating in the application. In addition, ECOA has prohibited a number of practices in mortgage loan underwriting, including refusing a loan based on an applicant's demographic characteristics. 7.14 B. $1,680. Monthly income qualification is derived by multiplying monthly income by the income ratio. Thus, 72,000/12 x.28 equals $1,680. Remember to first derive the monthly income. 7.15 B. Adjust the applicant's debt ratio calculation and lower the loan amount. Since a lender lends only part of the purchase price of a property according to the lender's loan-to-value ratio, a lender will verify that a borrower has the cash resources to make the required down payment. If someone is lending an applicant a portion of the down payment with a provision for repayment, a lender will consider this another debt obligation and adjust the debt ratio accordingly. This can lower the amount a lender is willing to lend. 7.16 C. All loans secured by a residence. Regulation Z applies to all loans secured by a residence. It does not apply to commercial loans or to agricultural loans over $25,000. Its provisions cover the disclosure of costs, the right to rescind the credit transaction, advertising credit offers, and penalties for non-compliance with the Act. 7.17 D. The borrower has a limited right to cancel the transaction within a certain period. A borrower has a limited right to cancel the credit transaction, usually within 3 days of completion of the transaction. The right of rescission does not apply to residential mortgage transactions, that is, to mortgage loans used to finance the purchase or construction of the borrower's primary residence. It does, however, apply to refinancing of mortgage loans, and to home equity loans. State law may require a rescission period and notice on first mortgage loan transactions as well. 7.18 b. Ask the buyer/borrower about his/her religion or national origin. ECOA prohibits discrimination in extending credit based on race, color, religion, national origin, sex, marital status, age, or dependency upon public assistance. A creditor may not make any statements to discourage an applicant on the basis of such discrimination or ask any questions of an applicant concerning these discriminatory items. A real estate licensee who assists a seller in qualifying a potential buyer may fall within the reach of this prohibition. 7.19 d. Not FHA insured or VA guaranteed. A conventional mortgage loan is a permanent long-term loan that is not FHA insured or VA guaranteed. FNMA does not back loans, FHA only insures FHA loans, and the VA, not GNMA, guarantees loans. 7.20 b. Limited by when the loan was originated. Rules for assumability vary according to when the FHA-insured loan was originated and whether the original loan was for an investment property or an owner-occupied principal residence. Loans originated before December 1, 1986, are generally assumable without restriction. Loans originated after December 1, 1986, require that the assumer show creditworthiness. Some mortgages executed from 1986 through 1989 contain language that is not enforced as a result of later congressional action. Mortgages from that period are now freely assumable, despite any restrictions stated in the mortgage. 7.21 c. How much of a loan the VA will guarantee. A veteran must apply for a certificate of eligibility to find out how much the VA will guarantee in a particular situation. 7.22 d. 0. If a loan is fully amortizing, its loan balance is 0 at the end of the loan term. 7.23 b. The buyer gives the seller a mortgage and note as part of the purchase price of the property. With a purchase money mortgage, the borrower gives a mortgage and note to the seller to finance some or all of the purchase price of the property. The seller in this case is said to take back a note, or to carry paper, on the property. 7.24 c. Hypothecation. The process of securing a loan by pledging a property without giving up ownership of the property is called hypothecation. 7.25 a. The borrower gives the lender a note and a mortgage in exchange for loan funds. When a borrower gives a note promising to repay the borrowed money and executes a mortgage on the real estate for which the money is being borrowed as security, the financing method is called mortgage financing. 7.26 c. The trustor conveys title to a trustee in exchange for loan funds from the beneficiary. A deed of trust conveys title to the property in question from the borrower, trustor, to a trustee as security for the loan. The trustee is a third-party fiduciary to the trust. While the loan is in place, the trustee holds the title on behalf of the lender, who is the beneficiary of the trust. 7.27 A. Title theory states that regard the mortgage document as a conveyance of ownership from the mortgager to the mortgagee are called title theory states. 7.28 B. Usury. Many states have laws against usury, which is the charging of excessive interest rates on loans. Such states have a maximum rate that is either a flat rate or a variable rate tied to an index such as the prime lending rate. 7.29 C. $1,200. A point is 1 percentage point of a loan amount. Thus, 2 points on a $60,000 loan equal 0.02x $60,000, or $1,200. 7.30 A. An amortized loan is paid off over the loan period. Amortized loans retire the principal balance over the loan period. If a loan does not do this, one must make a balloon payment at the end of the loan term to complete the loan payoff. 7.31 C. It is a negotiable instrument. A promissory note is a negotiable instrument, which means the payee may assign it to a third party. The assignee would then have the right to receive the borrower's periodic payments. 7.32 D. May be required to execute a release of mortgage document. Lenders may be required to release the mortgage or trust document to the borrower when the borrower has paid off the loan and all other sums secured by the document. The release clause, also known as a defeasance clause, may specify that the mortgagee will execute a satisfaction of mortgage, also known as release of mortgage and mortgage discharge, to the mortgager. 7.33 A. An appraisal report. Loan underwriting is the process of assessing the lender's risk in giving a loan. Mortgage underwriting includes evaluating the borrower's ability to repay the loan, appraising the value of the property offered as security, and determining the terms of the loan. 7.34 C. The ability to repay, the value of the collateral, and the profitability of the loan. A lender assesses risks by examining, or qualifying, both borrower and property. In qualifying a borrower, an underwriter weighs the ability of the borrower to repay the loan. In qualifying a property, an underwriter assesses the ability of the property value to cover potential losses. In this evaluation, a lender requires that the appraised value of the property be more than adequate to cover the contemplated loan and costs. Finally, the loan must make money for the lending organization as a basic business precept. 7.35 B. They want to ensure there is more than enough collateral to cover the loan amount. Without an ample difference between the property value and the loan amount, a drop in property values could cause the loan balance to exceed the collateral itself. This greatly increases the risk of a loan loss should the borrower default, since the balance could not be completely recovered in a foreclosure sale. 7.36 B. Consider the income of a spouse in evaluating a family's creditworthiness. The Equal Credit Opportunity Act, ECOA, requires a lender to evaluate a loan applicant on the basis of that applicant's own income and credit rating, unless the applicant requests the inclusion of another's income and credit rating in the application. In such a case, a lender may not discount or disregard income from part-time work, a spouse, child support, alimony, or separate maintenance. 7.37 A. Ensure the buyer has the earning power to make the loan payments. Both the income and debt ratios in borrower qualification quantify how much a borrower can safely afford to pay on a mortgage loan. The income ratio focuses on the borrower's earning power. 7.38 D. Debt payments divided by gross income. The debt ratio formula is debt obligations divided by income. 7.39 C. The parties complete all loan origination documents and the loan is funded. Closing of a mortgage loan normally occurs with the closing of the real estate transaction. At the real estate closing, the lender typically has deposited the funded amount with an escrow agent, along with instructions for dispersing the funds. The borrower deposits necessary funds with the escrow agent, executes final documents, and receives signed copies of all relevant documents. 7.40 B. Truth in Lending Laws and Regulations. Regulation Z, which implements the Truth in Lending Act, applies to all loans secured by a residence. It does not apply to commercial loans or to agricultural loans over $25,000. It prescribes requirements to lenders regarding the disclosure of costs, the right to rescind the credit transaction, advertising credit offers, and penalties for non-compliance with the Truth in Lending Act. 7.41 A. The Equal Credit Opportunity Act. ECOA prohibits discrimination in extending credit based on race, color, religion, national origin, sex, marital status, age, or dependency upon public assistance. 7.42 C. The Real Estate Settlement and Procedures Act. RESPA is a federal law which aims to standardize settlement practices and ensure that buyers understand settlement costs. RESPA applies to purchases of residential real estate, 1 to 4 family homes, to be financed by federally related first mortgage loans. In addition to imposing settlement procedures, RESPA provisions prohibit lenders from paying kickbacks and unearned fees to parties who may have helped the lender obtain the borrower's business. 7.43 B. Buying securities, changing the discount rate, and controlling banking reserves. The Federal Reserve System regulates the money supply by means of 3 methods: selling or repurchasing government securities, primarily Treasury bills, changing the reserve requirement for member banks, changing the interest rate, or discount rate. The system charges member institutions for borrowing funds from the Federal Reserve System. 7.44 A. It cycles funds back to primary lenders so they can make more loans. Secondary mortgage market organizations buy pools of mortgages from primary lenders and sell securities backed by these pooled mortgages to investors. By purchasing loans from primary lenders, the secondary market returns funds to the primary lenders, thereby enabling the primary lender to originate more mortgage loans. 7.45 A. Fannie Mae, Freddie Mac, and Ginnie Mae. As major players in the secondary market, the Federal National Mortgage Association, FNMA, Fannie Mae, Government National Mortgage Association, GNMA, Ginnie Mae, and Federal Home Loan Mortgage Corporation, FHLMC, Freddie Mac, tend to set the standards for the primary market. FHA, VA, and the Federal Reserve are not organizations in the secondary mortgage market. 7.46 C. It purchases FHA-backed and VA-backed loans. Fannie Mae buys conventional, FHA-backed, and VA-backed loans, gives banks mortgage-backed securities in exchange for blocks of mortgages, and sells bonds and mortgage-backed securities. It does not guarantee, insure, or originate loans. 7.47 B. It insures loans made by approved lenders. The Federal Housing Administration, FHA, does not lend money, but insures permanent long-term loans made by others. The lender must be approved by the FHA, and the borrower must meet certain FHA qualifications. 7.48 A. It guarantees loans made by approved lenders. The Veterans Administration, VA, offers loan guarantees to qualified veterans. The VA partially guarantees permanent long-term loans originated by VA-approved lenders on properties that meet VA standards. The VA's guarantee enables lenders to issue loans with higher loan-to-value ratios than would otherwise be possible. 7.49 C. The loan payments gradually increase. Graduated payment mortgages allow for smaller initial monthly payments which gradually increase. The interest rate remains fixed, as does the loan term. 7.50 B. The borrower pays additional interest at the onset in order to obtain a lower interest rate. A buy-down loan entails a prepayment of interest on a loan. The prepayment effectively lowers the interest rate and the periodic payments for the borrower. Buy-downs typically occur in a circumstance where a builder wants to market a new development to a buyer who cannot quite qualify for the necessary loan at market rates. National Test 8, Investments, Taxation, Ethics 8.1, B. Negative leverage. Leveraging is borrowing funds in order to make an investment that is larger than your own resource permits you to do directly. In negative leverage situations, your cost of borrowing funds to make the investment becomes greater than the income the investment returns to you. 8.2 B. Income properties. Cost recovery, or depreciation, allows the owner of income property to deduct a portion of the property's value from gross income each year over the life of the asset. Principal residences cannot be depreciated, unless portions are treated as a home office. Further, land cannot be depreciated. 8.3 C. 19.5%. Appreciation amount is the current value of the property minus the original cost. The total appreciation rate is derived by dividing the appreciation amount by the original cost. Subtract the estimated current market value from the price originally paid, $239,000 to $200,000 equals $39,000, and then divide the result by the original price, 39,000/200,000 equals 195 or 19.5%. 8.4. D. A deduction for mortgage interest. Deducting mortgage interest is a significant tax advantage of owning one's residence. Depreciation and cost deductions do not apply to a non-income producing residence. Appreciation is a benefit, but not a tax benefit. 8.5. D. $232,900. The figure for net proceeds from sale is expressed by the formula, sale price, costs of sale equals net proceeds. Thus $250,000, 6% x 250,000, 600 to 1,500 equals $232,900. 8.6. B. $157,000. The beginning basis is the cost of acquiring a property. Basis is increased by capital improvements and decreased by depreciation. The basic formula for adjusted basis is beginning basis, $150,000, plus capital improvements, $3,000 plus $4,000, depreciation, $0, equals adjusted basis, $157,000. 8.7. C. $34,000. The gain on sale, capital gain, of a primary residence is represented by the basic formula, amount realized, net sales proceeds, $210,000, adjusted basis, $176,000, equals gain on sale, $34,000. Note the purchase price of the second house is irrelevant. 8.8. A. There is no taxable gain. There is no taxable gain because the gain falls under the exclusion limit of $250,000. As of August 5, 1997, tax law provides an exclusion of $250,000 for an individual taxpayer and $500,000 for married taxpayers filing jointly on the gain from sale of a principal residence. The seller must have owned the property for at least 2 years during the 5 years preceding the date of sale, used the property as principal residence for a total of 2 years during that 5-year period, and have waited 2 years since the last use of the exclusion for any sale. 8.9. C. Direct investment. Individuals, corporations, or other investor entities may invest as active investors in a property by buying it directly and taking responsibility for managing and operating the property. This investment mode is called direct investment. 8.10. A. $2,100. Annual gross operating income, $1,500 x 12 equals $18,000, annual operating expenses, $500 x 12 equals $6,000, equals annual net operating income, $12,000, annual net operating income, $12,000, cost recovery expense, $5,000, equals taxable income, $7,000, taxable income, $7,000, x tax rate, 30%, equals tax liability, $2,100. 8.11 b. The more the investor stands to gain, the greater the risk that the investor may lose. The general rule in investments is that the safer the investment, the more slowly it gains in value. The more you want it to gain, and the more quickly, the more you must risk losing it. Reward in investing corresponds directly to the degree of risk. 8.12 a. Income and tax benefits. The basic financial rewards of an investment include income, appreciation in asset value, positive borrowing leverage, and tax benefits. 8.13 d. Relatively illiquid. Real estate is by nature more difficult to convert to cash than many other types of investment. Compare the selling of a home with the ease of drawing money out of a bank account or selling a stock. 8.14 b. A more management-intensive investment. Real estate tends to require a high degree of investor involvement in management of the investment. Even raw land requires some degree of maintenance to preserve its value. Improved properties often require extensive management, including repairs, maintenance, on-site leasing, tenant relations, security, and fiscal management. 8.15 a. A general partnership. A general partnership is a syndicate in which all members participate equally in managing the investment and in the profits or losses it generates. 8.16 d. Gross income minus expenses minus building depreciation. Taxable income from investment real estate is the gross income received minus any expenses, deductions, or exclusions that current tax law allows. Depreciation of land is not allowed. 8.17 c. Deduct interest payments from income. Taxable income is net operating income minus all allowable deductions. The interest portion of debt service is allowed and is deducted from net operating income as interest expense. Principal repayment is not an allowable deduction on investment properties. Capital gain derivation does not involve interest or principal payments. 8.18 d. The owner may be able to avoid capital gain tax when the property is sold. Provided the owner meets certain ownership and use tests, there is no capital gain tax on sale of the property unless the gain exceeds $250,000 for a single taxpayer or $500,000 for married taxpayers who file jointly. Since the property is not used for business, deductions for expenses against income are not allowed. 8.19 c. May be deducted from the sale price for gains tax purposes. Selling costs include such expenses as brokerage commissions, relevant advertising, legal fees, seller paid points and other closing costs. These costs are deducted from the selling price to get the amount realized, which is reduced by the adjusted basis to calculate gain on sale for gains tax purposes. 8.20 b. The difference between amount realized and adjusted basis. The formula for gain tax is taxable gain on sale x the owner's marginal tax bracket. The formula for gain on sale is amount realized, adjusted basis equals gain on sale. The formula for amount realized is selling price, selling costs equals amount realized. Therefore, the gain tax equals amount realized, adjusted basis, X tax rate. 8.21, C, a tax district. Real estate property taxes are imposed by taxing entities or taxing districts at county and local levels of government. States may legally levy taxes on real property, but most delegate this power to counties, cities, townships, and local taxing districts. The federal government does, however, tax income derived from real property and gains realized on the sale of real property. 8.22, B. Properties owned by a government agency. Certain types of property are exempt from property taxes. Certain classes of property owner may also be exempted or have a reduced liability. Exemptions include government-owned properties, real properties owned by churches, and properties owned by other non-profit organizations. 8.23, C. It adjusts assessments in a locality to make them more consistent with an average level for the state or other higher-level jurisdiction. Equalization factors level out the unevenness of valuations for groups of properties. For instance, if assessed values of properties in one county are consistently 10% below the average for other counties, an equalization board may multiply each assessed value in that county by a factor of 110% to raise them to the average level for the state. 8.24, C. $2 billion. The mill rate equals tax requirement / the tax base. A mill is 1/1000th of a dollar, $0.001. To solve for the tax base, reconfigure this formula to be base equals tax requirement / mill rate. Thus the base equals $20 million / 0.010, or $2 billion. 8.25, D. $441. The library tax is $1 x 147, and the fire district tax is $2 x 147. Thus the tax is $441. 8.26, B. $5,700. Special assessments are based on the cost of the improvement and apportioned on a pro rata basis among benefiting properties according to the value that each parcel will receive from the improvement. Here, Mary's share is 38/200, or 19%. 19% x $30,000 equals $5,700. 8.27, A. A conveyance instrument for a property that is sold to enforce a tax lien. A tax deed is a legal instrument for conveying title when a property is sold for non-payment of taxes. The application for a tax deed causes the taxing agency to institute a tax sale or tax foreclosure. 8.28, D. A statutory right of redemption. If the taxpayer can redeem the property after the tax sale, this right is known as a statutory right of redemption. In this case, the taxpayer must pay the amount paid by the winning bidder at the tax sale, plus any charges, additional taxes, or interest that may have accumulated. 8.29, B. The total of all assessed values of properties minus exemptions. The tax base of an area is the total of the appraised or assessed values of all real property within the area's boundaries, excluding partially or totally exempt properties such as those owned by the government or non-profit organizations. 8.30 C. Multiplying each district's tax rate times the taxable value of the property. Each property owner's tax bill is determined by multiplying the tax rate for each taxing district times the taxable value of the property. Taxable value is the assessed value after all exemptions and adjustments have been taken into account. 8.31 A. Civil Rights Act of 1866. The original Fair Housing Statute, the Civil Rights Act of 1866, prohibits discrimination in housing based on race. The prohibition relates to selling, renting, inheriting, and conveying real estate. 8.32 C. Race, color, religion, and national origin. Title 8 of the Civil Rights Act of 1968, known today as the Fair Housing Act, prohibits discrimination in housing based on race, color, religion, or national origin. 8.33 C. Advertising a property as available to individuals of a particular race. The prohibition against discriminatory advertising states that an agent may not advertise residential properties in such a way as to restrict their availability to any prospective buyer or tenant. 8.34 C. An agent persuades a family to put their house on the market because ethnic minority families are beginning to move into the neighborhood. Blockbusting, a prohibited activity, is the practice of inducing owners in an area to sell or rent to avoid an impending change in the ethnic or social makeup of the neighborhood that will cause values to go down. 8.35 A. The Home Mortgage Disclosure Act. The Home Mortgage Disclosure Act requires lenders involved with federally guaranteed or insured loans to exercise impartiality and non-discrimination in the geographical distribution of their loan portfolio. In other words, the Act is designed to prohibit redlining, the practice of restricting loans by geographical R.A. 8.36 C. Privately owned single-family residences listed with a broker. Among the circumstances where the Fair Housing Act might allow for an exemption is a privately owned single-family home where no broker is used, with certain additional conditions. In other words, as soon as a broker is used in the sale, the law applies. 8.37 A. Illegal, because the agent changed the terms of the sale to discourage this particular couple. The Fair Housing Act prohibition against discriminatory misrepresentation states that an agent may not conceal available properties, represent that they are not for sale or rent, or change the sale terms for the purpose of discriminating. 8.38 D. The owner of a duplex who resides in one of the units refuses to rent the other unit to a non-Christian. The Fair Housing Act would exempt the owner in this situation because it involves rental of an apartment in a 1 to 4 unit building where the owner is also an occupant and there is no discriminatory advertising. 8.39 B. File a complaint with HUD or file suit against the offending parties in a state or federal court within the prescribed time period. The Fair Housing Amendments Act of 1988 prohibits discrimination based on sex. If May feels she has been discriminated against in this way, she may file a complaint with the Office of Fair Housing and Equal Opportunity, OFHEO, in HUD within 1 year or file suit in a federal or state court within 2 years of the alleged violation. 8.40 A. Inform Scott that the condition is illegal and that she cannot comply with it. Scott is not allowed to discriminate based on race, color, religion, national origin, sex, family status, or handicap. If an agent goes along with a client's discriminatory act, the agent is equally liable for violation of fair housing laws. It is thus imperative to avoid complicity with client discrimination. Further, an agent should withdraw from any relationship where client discrimination occurs. 8.41 C. Require families without children to pay the same security deposit that families with children must pay. Fair housing laws prohibit discriminatory advertising, discrimination on the basis of national origin, discrimination based on age in dwellings of more than 4 units, and discrimination against families with children. The fact that the owner is requiring the same deposit from tenants with and without children does not discriminate against families with children but actually favors them. 8.42 D. It is a single-family house, and the owner owns only one other rental home in addition to his own residence. Federal fair housing laws do not prohibit age and family status discrimination in residential dwellings of 4 units or less and in single-family houses if sold or rented by owners who have no more than 3 houses. 8.43 C. The Fair Housing Amendments Act of 1988. The Fair Housing Amendments Act of 1988 prohibited discrimination based on sex and discrimination against handicapped persons and families with children. Executive Order 11063 concerned racial discrimination in housing where federal funding was involved. The Civil Rights Act of 1968 concerned discrimination based on race, color, religion, and national origin. Jones v. Meyer concerned racial discrimination. 8.44 C. Steering. Steering is the illegal practice of limiting customers' choices by encouraging or discouraging them about the suitability of an area and directing them only to areas the agent deems suitable for them. 8.45 A. Providing unequal services. The agent may be illegally providing unequal services by altering the nature or quality of brokerage services to a party based on race, color, sex, national origin, or religion. 8.46 A. Discriminatory misrepresentation by omission. Discriminatory misrepresentation is the concealing of available properties, representing that they are not for sale or rent, or changing the sale terms for the purpose of discriminating. National Test 9, Closings, Risk Management, Property Management 9.1, C. Returns funds to the buyer. If for any reason the transaction cannot be completed, the escrow instructions usually provide a mechanism for reconveying title to the seller and funds to the buyer. In such a case, both parties return to their original status as if no sale had occurred. 9.2 D. disclose in writing any business relationships they have with other parties involved in the transaction. Business relationships and affiliations among real estate firms, mortgage brokers, title insurance firms and other such companies that are involved in a transaction are permitted, provided the relationships are disclosed in writing to the consumer. The consumer is free to go elsewhere for the relevant service, and the companies do not exchange fees for referrals. 9.3 A. The item must be prorated and recorded as a debit to one party and a credit to the other party for the same amount. An income or expense item that affects both parties is apportioned, or prorated, to each party to reflect the proper amount that each owes or should receive. A prorated item is treated as a debit to one party and a credit to the other party for the same amount. 9.4 B. At some time after the expense is incurred. Items paid in arrears are paid after the expense has been incurred. 9.5 D. A debit to the seller and credit to the buyer for $580. For income the seller received in advance, the buyer receives a credit and the seller receives a debit. In effect, the seller has received some of the buyer's income, and the seller must pay this share to the buyer. Therefore the seller is debited and the buyer is credited the $580 the buyer is entitled to earn as the new owner. 9.6 B. A debit to the seller and credit to the buyer for $43. For an item the buyer will pay in arrears, the buyer receives a credit and the seller receives a debit. In effect, the seller has incurred some of the expenses that the buyer will be paying for after closing. Thus the seller must pay the buyer the used portion of the expense, or $43. 9.7 B. $546. The daily tax expense, first, is $2,190 divided by 365, or $6. Since the buyer will pay the taxes after closing, the seller will owe the buyer his or her portion of the tax bill, which is the 91 days from the beginning of the year through closing. Therefore, credit the buyer and debit the seller, $6 x 91, or $546. 9.8 D. $191.67. This method assumes all months are 30 days and the year is 360 days. The daily proration is therefore $375 divided by 360, or $1.04. The closing occurs on the 184th day of the year. Thus, $1.04 x 184 equals $191.67. Note that if the day of closing is the buyer's, there would be 183 days worth of prorated expense. 9.9 D. $735.34. Assuming a 365-day year, the daily tax expense is $1,100 divided by 365, or $3.013. As taxes are paid in arrears, the buyer will be paying the annual bill. Thus, he will be owed a credit for the seller's share of the bill, which is $3.013 x 244 days, or $735.34. 9.10, A, $116.03. The buyer's share is the unused portion, or 365 days, 244 days, or 121 days. The daily expense is $350 divided by 365, or $0.9589. $0.9589 x 121 equals $116.03. The seller receives this amount as a credit and the buyer a debit. 9.11, A, $507.50. If the buyer pays $525 interest for 30 days, the daily expense is $525 divided by 30, or $17.50. If there are 29 days of prepaid expense, the buyer's charge is $17.50 x 29, or $507.50. 9.12, C, $1,775. $88,750 x 0.02 equals $1,775. Remember, 1 point equals 1% of the loan amount. 9.13, D, $11,250. $187,500 x 6% equals $187,500 x 0.06 equals $11,250. 9.14, D, the buyer must pay the expense. Explicit agreements in the sale contract supersede traditional expense payment responsibilities which can vary from state to state. 9.15, A, the excess of the buyer's debits over the buyer's credits. To determine how much money the buyer owes at closing, the buyer's debits are totaled and compared with the total of the buyer's credits. The excess of debits over credits is the amount the buyer must bring to the closing. 9.16, D, negligence, error, or omission in carrying out professional services. A standard E&O policy provides coverage for damages resulting from any negligent act, error, or omission arising out of professional services. It does not cover dishonest or illegal acts, including environmental violations and mishandling of funds. 9.17, A, failing to inform and disclose properly. Agency risks commonly concern the requirement to inform and disclose. Most states require agency relationships to be in writing and to be disclosed to all parties to a transaction. In states that do not use agency, there is still the obligation to explain and disclose the nature of the relationship. 9.18, B, failing to disclose known adverse facts. Depending on the state, the licensee may have no further duty to disclose property condition after properly informing parties of their rights and obligations. However, the licensee may still be subject to legal action for failing to disclose adverse facts the licensee knew about or should have known about. 9.19, D, avoid creating a false impression that the licensee is a certified appraiser. Misuse of such terms as appraisal and value could lead to a charge of misrepresenting oneself as an appraiser. 9.20 b. Exceeding the authority of the agreement. Licensees must stay within the bounds of the authority granted by the agency agreement and avoid doing anything requiring permission without first getting that permission in writing. 9.21 a. Use a checklist of all items, contingencies, dates, and responsibilities that must be met. One way to reduce risk in the contracting process is to use a checklist that covers all the contract items, such as inclusions and exclusions, contingency periods, documents, forms, data checking, and milestone dates. 9.22 d. The principals may make changes as long as they sign or initial each change. Real estate professionals who are not attorneys are usually limited to filling in blanks or making deletions on a pre-printed contract form prepared by a lawyer. While a licensee may make deletions, additions to a form should be drafted by an attorney. The principals themselves can make changes as long as each change is signed or initialed by all signers. 9.23 b. Obtain education in the content and intent of the laws. The risk of violating fair housing laws can be minimized through ongoing education that addresses both the intent of the laws and their current content. 9.24 a. Being present at a conversation where the setting of commission rates is discussed. Antitrust laws forbid brokers to band together to set a price on their services in listing and selling property. Even being overheard discussing commission rates or being present at such a conversation can lead to charges of price fixing. 9.25 a. License discipline, fines, and possible incarceration. Intentional misrepresentation, as a type of fraud, is a criminal act that may result in fines and incarceration, in addition to discipline from state regulators and professional organizations. 9.26 c. Stating that a client should seek legal counsel. Unintentional misrepresentation occurs when a licensee unknowingly gives a consumer inaccurate information concerning a property, financing, or agency service. Information that the licensee, as a professional, should have known to be false or inaccurate may be included in the definition. Telling a client that legal counsel would be advisable is not misrepresentation and, in fact, is often an important risk management technique. 9.27 d. Avoid speculative statements in all reports. Progress reports should be accurate, timely, in writing, and free of speculation. Speculation may encourage the consumer to believe the agent has expertise that in fact is non-existent. If a consumer has a question about the meaning of something in an inspection report, the licensee should refer the consumer to the person who wrote the report rather than trying to explain it. 9.28 b. It reduces the chance of presenting an offer from an unqualified buyer. Using a lender to qualify the buyer protects the agent against leading a seller to believe a purchaser is fully qualified when this may not be the case. Also, lenders and loan agents are better able to look into the buyer's qualifications than a real estate licensee is. If it is necessary to show a property to a potential buyer who has not been qualified by a lender, the licensee can gain some protection by performing an informal qualification and documenting the fact that it was based on the information provided by the buyer. 9.29 C. The agency relationship. Maintaining the confidentiality of any information that would harm the client's interests or bargaining position or anything else the client wishes to keep secret, unless the law requires disclosure, is one of the primary duties of agency. The duty to maintain confidentiality generally survives the termination of a listing agreement into perpetuity. 9.30 A. Performing a comparative market analysis. In preparing a comparative market analysis, licensees should guard against using the terms appraisal and value, which are reserved for the use of certified appraisers. Misuse of these terms could lead to a charge of misrepresenting oneself as an appraiser. 9.31 D. Make a substantial misrepresentation. The license laws of most states list as illegal advertising activities subject to discipline such actions as making any substantial and intentional misrepresentation, making false promises, and making misleading or untruthful statements in any advertising. 9.32 C. Fiduciary. The management agreement creates an agency relationship between the manager and the principal. This is a fiduciary relationship and, in general, the agent is charged with producing the greatest possible net return on the owner's investment while safeguarding the value of the investment for the owner/investor. 9.33 B. Financial reporting to the principal. Financial reporting to the principal is a fundamental responsibility of the property manager. Reports may be required monthly, quarterly, and annually. Required reports typically include operating budget, cash flow, profit and loss, and budget comparison statements. 9.34 D. Revenue from all sources minus losses from uncollected rents, vacancies, and evictions. The total of scheduled rents plus revenues from such sources as vending services, storage charges, late fees, utilities, and contracts is the potential gross income. Subtracting losses caused by uncollected rents, vacancies and evictions gives effective gross income. 9.35 A. Cost per tenant prospect generated per lease. The efficiency of marketing activities can be judged in terms of how many prospects per completed lease they generate. The lower the cost per prospect per lease, the more effective and efficient the program. 9.36 B. Raise rental rates. Vacancy rates are directly related to demand and competitive supply in the market. If vacancy rates in the managed property are too high, the manager may have to lower rates or identify problems in the property or its management that are contributing to vacancy level. On the other hand, if the property's vacancy rate is significantly lower than market rates, the manager may conclude that higher rental rates are called for. 9.37 B. Routine, preventive, and corrective. The foremost maintenance objective is generally to preserve the value of the physical asset for the owner over the long term. 3 general types of maintenance are required to keep a property in serviceable condition: routine, day-to-day, preventive, scheduled, and corrective repairs and replacements. 9.38 A. Ensure that disabled employees have the same level of access to facilities that all employees have. Employers with at least 15 employees must follow non-discriminatory employment and hiring practices and make reasonable accommodations to enable disabled employees to perform essential functions of their jobs. Modifications to the physical components of the building may be necessary to provide the required access to tenants and their customers. Existing barriers must be removed when the removal is readily achievable, that is, when cost is not prohibitive. 9.39 A. Replacement value. The amount of coverage provided by certain types of policies may be based on whether the property is insured at depreciated value or current replacement value. Depreciated value is original value minus the loss in value over time. Current replacement value, which is more expensive, is the amount it would cost to rebuild or replace the property at current rates. Commercial policies include co-insurance clauses requiring the insured to bear a portion of the loss. Fire and hazard policies usually require the coverage to be in an amount equal to at least 80% of the replacement value. 9.40 B. Cash for the management firm's operating expenses. Managers are responsible for proper handling of monies belonging to other parties, trust funds, that come into the manager's hands in the course of doing business. For property managers, such trust funds include rents collected from tenants, security deposits, and capital contributions from the property owner. Funds belonging to the management firm must not be commingled with those of the client. 9.41 C. General property managers are usually considered to be general agents empowered to perform some or all of the ongoing tasks and duties of operating the property, including the authority to enter into contracts. 9.42 B. The tenant pays a fixed rent, and the landlord pays all operating expenses. In a gross lease, the tenant pays an established, fixed rent, and the landlord pays all property operating expenses, such as taxes, insurance, utilities, and other services. This is the arrangement commonly used in residential leases. If the tenant pays some of the operating expenses, the lease is a form of net lease. 9.43 D. The property manager does not have to maintain it. The lease should set forth items that are excluded or included in the leased property. For instance, a residential lease may include built-in appliances such as dishwashers but exclude freestanding ones, such as refrigerators. At issue for the landlord is the cost of maintenance. If a refrigerator is not included, it does not have to be maintained by the property manager. 9.44 B. Deliver a habitable property. The landlord, by way of the property manager, is expected to deliver a property that is habitable. This means keeping heating, plumbing, cooling, and electrical systems in good repair as well as maintaining serviceability of floors, stairways, railings, roofs, and windows. 9.45 C. A tenant declares a landlord in default and vacates the leased premises. A constructive eviction occurs when a tenant vacates the leased premises and declares the lease void, claiming that the landlord's actions have made the premises unfit for the purpose described in the lease. The tenant must prove that it was the landlord's actions that were responsible and may be able to recover damages. 9.46 A. The competitive market for the property. In preparing a management plan, a manager must consider the owner's objectives, including financial goals, the competitive market for the property, both local and regional, depending on the property type, and the features of the particular property. The plan will also include a budget and indications of what the manager intends to do with the property to meet the owner's objectives. National Test 10, Real Estate Math 10.1, A. $0.23/SF5/6 ths of an acre equals 5x 43,560 SF/6, or 36,300 SF. Her commission was 0.06x $28,000, x 0.50, or $840. $840/36,300 SF equals $0.023/SF. 10.2 B. $370,170. The land costs $0.50 x 43,560 SF/AC x 1.5 AC, or $32,670. The home will cost $135/SF x 2,500, or $337,500. The total property will cost $370,170. 10.3 A. 12%. The lot measures 43,560/4, or 10,890 SF. The tennis court will take up 9,600 SF, leaving 1,290 SF. This amount is 11.8% of the total lot area. 10.4 C. 40. The total area available for lots is 11.2 acres, 16 acres x 70% for houses, or 487,872 SF, 11.2 x 43,560. Dividing this area by 12,000 SF/lot equals 40.66. Thus he can have a 40-lot subdivision. 10.5 A. 6 First, the requirement equals 2, 13x9, plus 2, 18x9, equals 558 SF. Each roll is 2x50, or 100 SF. Thus she will need 6 rolls. 10.6 D. 1,376 SF. First figure the area to be mulched. If the home is 40x30, the flower area adds 8 to each side of the house. Thus the outside perimeter of the flowered area is 40 plus 8 plus 8, by 30 plus 8 plus 8, or 46 by 56. The area of the flowered area is 46x56, minus the house area of 1,200 SF. This is 1376 SF. 10.7, b. 40 acres first. Remember that a section contains 640 acres. The area in question is a fourth of a half of the total section. So divide 640 by 4x2x2. 4x2x2 is 16 and 640/16 equals 40 acres. 10.8, c. 10 acres. This key to this question is to recall that a section has 640 acres. Teresa's property only is a 1/4 of a 1/4 of a 1/4 of the entire section. Multiply 4x4 which equals 64. Savannah owns 1/64 of the section. Divide 640 by 64 and you get the answer of 10 acres. 10.9, a. $38,955. Their fixed rent is 1,800 SFX $1.40/SF, x 12 months, or $30,240. The percentage rent is $41,500 x 0.0175, x 12, or $8,715. Total rent is $30,240 plus $8,715, or $38,955. 10.10, a. 5.04% first, convert to decimals. 2 2/3% equals 2.67%, 5 1/5% equals 5.2%, 7 1/4% equals 7.25%. Thus total appreciation equals 2.67% plus 5.2% plus 7.25%, or 15.12%. Divide by 3 to derive the average. 15.12%/3 equals 5.04%. 10.11, c. 29%. Appreciation as a percent can be estimated by 1. Subtracting the estimated current market value from the price originally paid, 239,000 to 185,000 equals 54,000, and 2. Dividing the result by the original price, 54,000/185,000 equals 29 or 29%. 10.12, c. 94%. To find the percent of listing price the offer is, divide the offer by the listing price. In this question the offer is $290,000 and the listing price is $308,000. Percent $94,000,308,000,290. 10.13, a. $206,000. Remember the formula V equals I/R, where V is value, I is annual income, and R is the cap rate. Variations of this are, R equals I/V in solving for the cap rate, and I equals VXR in solving for income. Here, first identify net income by subtracting out vacancy and expenses. Then divide by the capitalization rate. Thus, $30,000 to $1,500, 10,000, /9% equals $205,555, or $206,000 rounded. 10.14, B, $375,000. Value equals income/cap rate. Thus, V equals $30,000/0.08 equals $375,000. 10.15, B, $13,600. First derive the annual depreciation, which is the cost divided by the economic life. Then multiply annual depreciation times the number of years to identify total depreciation. Remember to subtract depreciation from the original cost if the question asks for the ending value. Thus, $16,000/20 years x 3 years equals $2,400 total depreciation. The ending value is $16,000 to $2,400, or $13,600. 10.16, A, $1,077 first, least depreciable basis, without the land, is $280,000 x 75%, or $210,000. The annual depreciation for the entire home is $210,000/39 years, or $5,384.61. Second, his office is 20% of the house, 500 SF/2500 SF. Therefore Lee can take annual depreciation of $5,384.61 x 20%, or $1,076.92. 10.17, D, $188,000. Cost approach formula: land plus cost of improvements plus capital additions, depreciation, equals value. Thus you have $40,000 plus $175,000 to $27,000, or $188,000. 10.18, C, $475,000. Use the same cost approach formula: land plus cost of improvements plus capital additions, depreciation, equals value. The land is worth $100,000 x 125%, or $125,000. Remember, you cannot depreciate the land, only the cost of the improvements. Therefore, annual depreciation is $400,000/40, or $10,000. Total depreciation is $10,000 x 5 years, or $50,000. Thus the value is $125,000 plus $400,000 to $50,000, or $475,000. 10.19, D, $125. Use the formula, GRM equals price/monthly rent. Thus, $400,000/$3,200 equals $125. 10.20, C, $194,000. Use the formula, GIM equals price/annual income. To solve for price, convert the formula to price equals GIM x annual income. Thus, $1,100 x 12 equals $13,200 annual income. $13,200 x 14.7 GIM equals $194,040, or $194,000 rounded. 10.21 d. $750. The loan amount is $200,000 x 0.75, or $150,000. The first month interest equals $150,000 x 6%, / 12 months, or $750. 10.22 b. $179,000. The equation for the loan amount is annual interest divided by the interest rate equals loan amount. Thus, $790 x 12 / 0.053 equals $178,868, or $179,000 rounded. 10.23 a. 4.82%. The equation for the interest rate is annual payment / loan amount equals interest rate. Thus, $1,000 x 12 / $249,000 equals 4.82%. 10.24 b. $1,456.95. In the first month they pay interest of $280,000 x 6.25%, / 12, or $1,458. If their fixed payment is $1,724, they paid down the principal by $266, $1,724 to $1,458. Now they must pay 6.25% interest on the new principal balance of $279,734. This equals $279,734 x 0.0625, / 12, or $1,456.95. 10.25 b. The second option, by 150. The first option's interest total is 6.5% x $60,000, x 5 years, or $19,500. The second option will charge 6.25% x $60,000, x 5 years, plus $600, or a total of $19,350. The second option is $150 cheaper. 10.26 b. 1.67 points. A discount point is 1% of the loan amount. Jose's loan is $410,000 x 90%, or $369,000. If he paid $6,150, he paid 1.67% of the loan amount, $6,150 / $369,000, or 1.67 points. 10.27 c. $4,875. $325,000 x 0.015 equals $4,875. Remember, 1 point equals 1% of the loan amount. 10.28, C. $162,500. Use the formula, price x LTV ratio equals loan. Then plug in the figures and calculate, price x 0.80 equals $130,000. Therefore, price equals $130,000 slash 0.80 equals $162,500. 10.29, C. $379,259. First, the annual interest paid is $1,600 x 12, or $19,200. The interest rate is 6.75%. Using the formula, loan equals interest slash rate, the loan amount is $19,200 slash 6.75%, or $284,444. As this is 75% of the price is $284,444 slash 0.75, or $379,259. 10.30, B. $1,900. Monthly income qualification is derived by multiplying monthly income by the income ratio. Thus, 76,000/12, x 0.30 equals $1,900. Remember to first derive the monthly income. 10.31, A. $253,846 total depreciation on this property equals $600,000/39 years, x 10 years, or $153,846. His adjusted basis is therefore $680,000 original price, $153,846 depreciation taken, or $526,154. The gain is then $780,000 to $526,154, or $253,846. 10.32, B. $257,000. Adjusted basis equals beginning basis, $250,000, plus capital improvements, $2,000 plus $5,000, depreciation, 0, equals adjusted basis, $257,000. 10.33, C. $34,000. Capital gain equals amount realized, net sales proceeds, $265,000, adjusted basis, $231,000, equals $34,000. 10.34, D. $125,000. The basic formula for adjusted basis is, beginning basis plus capital improvements, exclusions and credits equals adjusted basis. Deborah's adjusted basis is therefore $120 plus $5,000 equals $125,000. The financing terms and subsequent selling price are not relevant. 10.35, C. $15,000 overpriced. Use the same formula V equals I/R, where V is the price and R is the rate of return. Then plug in the numbers to solve for V. The NOI of this property is $60,000, $22,000, or $38,000. The return is 11%. Therefore, the value to get this return must be $38,000/0.11, or $345,455. Since the price is $360,000, the price exceeds the amount needed for an 11% return by approximately $15,000, $360,000 to $345,455 equals $14,545. 10.36 B. Yes, since he will yield 8.375%, use the same formula R equals I/V, where V is the $2 million price, and R is the cap rate or rate of return. To identify income, 25,000 SF x $10/SF equals $250,000 gross income, minus 5% vacancy, 0.05 x $250,000, or $12,500, minus expenses of $70,000 equals $167,500 net income. $250,000 to $12,500, $70,000. Now divide net income of $167,500 by $2 million to derive the return of 8.375%. 10.37 A. $1,680. Annual gross operating income, $1,650 x 12 equals $19,800. Annual operating expenses, $600 x 12 equals $7,200, equals annual net operating income, $12,600. Annual net operating income, $12,600. Cost recovery expense, $7,000, equals taxable income, $5,600. Taxable income, $5,600. X tax rate, 30%, equals tax liability, $1,680. 10.38 C. $10,640. The basic formula for tax liability is taxable income x tax rate equals tax liability. Taxable income is net operating income, interest expense, cost recovery expense. Therefore, the annual tax is $150,000, NOI, $105,000, interest expense, $7,000, cost recovery expense, x 28% equals $10,640. Note that the principal payment is not deductible in calculating taxable income. 10.39 D. 31.4%. The formula for profit percent is profit/initial investment. The profit made was $23,000 x 4, $70,000 initial investment, or $22,000. Dividing this by the amount invested derives a profit percent of 31.4%. 10.40, c. $1 billion. The mill rate equals tax requirement / the tax base. A mill is 1/1000th of a dollar, $0.001. To solve for the tax base, reconfigure this formula to be base equals tax requirement / mill rate. Thus the base equals $10 million / $0.010, or $1 billion. 10.41, a. $1,495 first, always use the assessed valuation, not the market value. Subtract out the homestead exemption to derive taxable value, or $140,000 to $25,000 equals $115,000. As a shortcut to calculating the tax bill, simply add up all the mills, multiply them times 0.001 to convert mills to decimals, then multiply this number times the taxable value. Thus, 7 plus 3 plus 2 plus 1, x.001 x $115,000 equals $1,495. 10.42, b. 2.13% The rate equals budget / tax base. Thus, $8 million / $400 million to $25 million, equals 2.13%. 10.43, d. $1,778. First calculate the total commission, then the co-brokerage splits, then the agent-broker split. Thus, $127,000 x 7% equals $8,890 total commission. $8,890 x 50% equals $4,445 total listing broker share. $4,445 x 40% equals $1,778 agent's share. 10.44, a. $6,866 figure the total commission, then the co-brokerage splits, then the broker-agent splits. Thus, $325,000 x 6.5% equals $21,125. $21,125 x 50% equals $10,563. $10,563 x 0.65 equals $6,866. 10.45, c. A credit to the buyer and debit to the seller for $785.34. The daily tax expense, first, is $3,150/365, or $8.63. Since the buyer will pay the taxes after closing, the seller must pay the buyer his or her portion of the tax bill at closing, which is the 91 days from the beginning of the year through closing. Therefore, credit the buyer and debit the seller, $8.63 x 91, or $785.34. 10.46, a. $507.50. If the buyer pays $525 interest for 30 days, the daily expense is $525/30, or $17.50. If there are 29 days of prepaid expense, the buyer's charge is $17.50 x 29, or $507.50. 10.47 D. Credit buyer $712.26. For the monthly proration using the 365-day method, solve first for the daily rent amount, $1,380/31, or $44.52. Since the landlord received the rent and owes the buyer portions of the rent, the buyer will be credited. The owed amount is for the 16th through the 31st, or 16 days, since the closing day belongs to the buyer. Therefore, credit the buyer and debit the seller, $44.52 x 16, or $712.26. 10.48 D. $86,372. First calculate the transfer tax, $322,600/500, equals 645.2 units of $500. Round this up to 646, then multiply times $1 to get $646 transfer tax cost. Next figure the commission at $322,600 x 0.07, or $22,582. Next, the seller's real estate tax proration charge will be $2,000. Then, add up the expenses, $646 transfer tax plus 450 title plus 550 attorney plus 22,582 commission plus 210,000 loan payoff plus 2,000 tax proration, equals $236,228. Subtracting this from the sale price equals $86,372. 10.49 D. $5,848. Be careful here. Since the net price is $5,000, the taking price, TP, minus the commission must equal the net price. In other words, the net price is 90% of the taking price. Since TP x 90% equals net, TP equals net/90%. So the taking price is $5,556, $5,000/0.9. Apply the same logic to deriving the asking price. The taking price is 95% of the list price, therefore the list price equals taking price/95%, or $5,848. Now work backwards to prove your answer. 5,848 x 95% margin x 0.90 net of commission, equals $5,000. 10.50 D. $468,750. Use the formula, percent of insurable property value carried /80% replacement cost, X claim equals recovery, where the insurable property value variable excludes the land value and is valued at replacement cost. Here, the insurable portion of the property is $740,000, 25% land value, or $555,000. The Wilds are carrying insurance to cover 75% of the replacement cost of the entire property. Their recovery amount is therefore 75%/80%, x $500,000, or $468,750. 10.51, c. $140,000. Use the formula, percent of insurable property value carried /80% replacement cost, x claim equals recovery. Thus, 75%/80% x $150,000 equals $140,625. However, the face value of the policy is the maximum they can receive, which is $140,000. State Test 11, Commission Duties and Powers 11.1, c. 5 members. The Nevada Real Estate Commission has 5 members. CNRS 645.050. 11.2, b. 1 is required to be from Washoe County. Effective July 1, 2015, 3 commissioners must be from Clark County, 1 from Washoe County, and 1 from the remainder of the state. UB 410, not yet codified. 11.3, b. Appointed by the Governor. Nevada Real Estate Commissioners are appointed by the Governor. CNRS 645.050. 11.4, b. 3 years. Nevada Real Estate Commissioners serve 3-year terms. CNRS 645.060. 11.5, a. 2 consecutive terms. A Nevada Real Estate Commissioner can only serve 2 consecutive terms. 11.6, b. At least a Nevada Real Estate Broker Salesperson. A Nevada Real Estate Commissioner must be a broker or a broker salesperson. A broker must have 3 years of active experience immediately preceding appointment, and a broker salesperson must have 5 years of active experience immediately preceding appointment. 11.7, d. 3 years after serving 2 consecutive terms, a person must wait 3 years before serving another term as a Nevada Real Estate Commissioner. 11.8, a. Adopts regulations. The legislature enacts statutes and courts adjudicate complaints. The Real Estate Commission adopts regulations to implement and interpret NRS 645. 11.9, c. The Nevada Real Estate Commission. The Nevada Real Estate Commission conducts disciplinary hearings when licensees are charged with violating license law. 11.10, c. The Nevada Real Estate Commission. The Nevada Real Estate Commission regulates real estate education in Nevada. 11.11, d. Advisory. Although the Real Estate Commission has a lot of authority, it acts in an advisory capacity to the Real Estate Division. 11.12, b. the Nevada Real Estate Division. The Nevada Legislature, through an enabling statute, has delegated the administration of the real estate law to the Real Estate Division, with the Real Estate Commission acting in an advisory capacity. 11.13 b. Administrator. By statute, the Chief Executive Officer of the Real Estate Division is called the Administrator. 11.14 c. Cannot be affiliated with a real estate brokerage firm. Real estate commissioners must be affiliated with a brokerage, but the administrator cannot be affiliated with a brokerage. 11.15 a. Whether the licensee has treated all parties fairly. This is one of the factors that can be considered pursuant to NAC 645.605. 11.16 d. Whether the licensee has communicated with his or her client on a regular basis. It is important for a licensee to communicate frequently with a client, but it is not a factor used to determine whether the licensee has engaged in misconduct. 11.17 a. Whether the licensee has a college degree. A licensee's level of education is not a factor in determining whether a licensee has engaged in misconduct. 11.18 d. No, he got assistance from a residential agent and disclosed his lack of experience to the client. A licensee is not subject to discipline for acting outside his area of competence if he discloses his lack of experience or lack of competence to the client and obtains assistance from a qualified authority. Carl did both. However, Carl could still be subject to a lawsuit for the mistakes that were made. 11.19 a. Yes, Betty failed to ascertain pertinent facts about the property. A licensee can be disciplined for failure to ascertain all pertinent facts about the property which is the subject of the transaction. Betty should have researched the client's question before answering it. 11.20 d. Yes. Sally must disclose her ownership interest in the seller LLC regardless of how small the ownership interest. The fact that she is charging a minimal commission is irrelevant. The fact that she does not expect any profit does not negate her duty to disclose. 11.21 d. Yes, an expiration date is required in all brokerage agreements. It is illegal to write a brokerage agreement that lacks an expiration. 11.22 c. $25,000/$100,000. The maximum recovery from the Education Research and Recovery Fund is $25,000 per claim and $100,000 per licensee. 11.23 a. 5 years. A broker must retain records for 5 years. Other licensees do not have record retention requirements. 11.24 a. Broker salesperson. There are 3 basic types of real estate licenses in Nevada: broker, broker salesperson, and salesperson. 11.25 d. Yes, the expectation of payment is enough. Rhonda is helping Brian with a real estate transaction with the expectation of being paid. She needs a license. NRS 645.030. It makes no difference whether she does not get paid, or does not have an agreement to get paid. 11.26 a. No, Ryan must have a real estate license to be paid for performing the services of a real estate licensee. An agreement to pay an unlicensed person is unenforceable. 11.27 c. Someone transacting mining claims. Mining claims are exempt from Nevada's real estate license law. An appraiser, home inspector, or loan officer must have a real estate license to engage in the activities of a real estate licensee. 11.28 d. is exempt from the Nevada real estate licensing requirement. An attorney, when performing her duties as an attorney, is exempt from the license law. 11.29 b. Property management. Property management and business brokerage each require a real estate license and a special permit. The permit is not needed for the other activities listed. 11.30 c. Have a designated broker. Business entities are required to have a designated broker. For a partnership, it must be a partner. For a corporation, an officer. For a limited liability company, the manager. 11.31 b. No, she is not being compensated or expecting any compensation. A real estate license is only needed when someone works for compensation or the expectation of compensation. Sheila cannot obtain a real property management permit without a real estate license. 11.32 c. 90 hours. 90 hours of pre-license education, including 18 hours of Nevada law, are required to obtain a salesperson's license. 11.33 b. 64 credits. 64 college credits are required to obtain a real estate broker's license. 16 credits are obtained for every 2 years of active experience. 11.34 b. Cannot engage in any activities that require a license. The person with an inactive license cannot engage in any activities that require a license. Property management activities require a real estate license and property management permit. 11.35 a. 12 months. An initial license is valid for 12 months. To renew, the licensee must complete the prescribed post-license course. 11.36 a. 24 months. After the first renewal, a license is valid for 24 months. To renew, the licensee must complete 24 hours of continuing education. 11.37 d. Placed on inactive status. When a broker's license is expired, suspended, or revoked, the licenses of affiliated licensees become inactive. 11.38 b. We sell M-Fast broker. When a licensee changes brokerage affiliations, he employing broker must notify the division within 10 days and submit the licensee's license. The division will send the license to the new broker. If the brokers agree in writing, the licensee may carry his license to the new broker. State Test 12, Property Disclosures, Record Keeping, Contracts, Advertising. 12.1 c. At least 10 days before the close of escrow, the seller's real property disclosure form must be delivered to the buyer. By law, at least 10 days before the close of escrow. This time period is often shortened by agreement of the parties. 12.2 b. 5 calendar days after receipt of the resale package, a buyer has until midnight of the 5th calendar day to rescind the transaction. 12.3 A. Resale package. By statute, the collection of documents given by a seller to a buyer in a common interest community is called the resale package. It is sometimes also referred to as the HOA docs. 12.4 D. 4 working days. Although it is an unusual number, a buyer has 4 working days after receipt of the seller's real property disclosure form to rescind the transaction. 12.5 A. Seller. The seller's agent can help explain the document to the seller, but the seller must complete the seller's real property disclosure form. 12.6 B. Disclose in writing that the defect has gotten worse. If, after delivery of the seller's real property disclosure form, a new defect is discovered, or a disclosed defect has worsened, the seller must disclose the change to the buyer in writing before conveyance of the property. 12.7 A. Residential Disclosure Guide. The Residential Disclosure Guide is given by licensees to prospective buyers and sellers. Other documents listed are given by the seller to a buyer. 12.8 C. Residential Sales Transactions Only. The seller's real property disclosure form is only required in residential sales. 12.9 D. In all residential sales transactions where the property is located in a common interest community. The resale package is required in all residential sales transactions where the property is located in a common interest community. The resale package is in addition to, and not in lieu of, the seller's real property disclosure form. 12.10 A. Minutes of Executive Board Meetings. Minutes of Executive Board Meetings are no longer a required component of the resale package. 12.11 A. The unit owner, seller, or his agent. The law requires the unit's owner, or his or her authorized agent, to furnish to a resale package to the buyer at the owner's expense. The unit owner must request the homeowners association to provide the necessary documents for inclusion in the package. 12.12 B. 10 days. The homeowners association has 10 days to deliver the contents to the owner after a proper written request. 12.13 B. 5 business days. The purchaser may, by written notice, cancel the contract of purchase until midnight of the 5th calendar day following the date of receipt of the resale package. 12.14 B. Resale package. The resale package is sometimes referred to as the homeowners association documents. 12.15 C. $9,000 plus attorney's fees and costs if the buyer does not receive a seller's real property disclosure form and later discovers a defect of which the seller was aware. The buyer can obtain treble damages plus attorney's fees and costs. 12.16 C. Open range disclosure. When property is located adjacent to the land where domesticated animals are allowed to roam or graze, the seller must give to the buyer, before the buyer signs an offer, an open range disclosure form. 12.17 B. 5 years. A real estate broker must retain real estate transaction records for 5 years. 12.18 B. No, a broker must number each real estate transaction consecutively or index to permit audit by a representative of the real estate division. 12.19 A. 5 calendar days. A salesperson or broker salesperson must provide any paperwork to the broker with whom she is associated within 5 calendar days after that paperwork is executed by all the parties. 12.20 D. Salespeople are not required to maintain transaction records. Brokers, not salespeople or broker salespeople, are responsible for maintaining records. 12.21 A. In the state of Nevada, a complete record of each real estate transaction along with trust account records must be kept in the state of Nevada. It is not required that the records be in electronic format. 12.22 C. A real estate salesperson may not be the only signatory on a trust account. A real estate salesperson may be a cosigner of an account with his or her real estate broker, but may not be the sole required signatory. 12.23 D. This is insufficient because he must advise the division of the exact location of the records. The real estate broker must give written notice to the division of the exact location of the records. 12.24 A. The records cannot be moved until the real estate division is notified of the new location. A broker does not need permission from the real estate division to move her records, but the records cannot be moved until the real estate division is notified of the new location. 12.25 B. 2 accounts. A property manager must maintain at least 2 trust accounts. One for rental operations and one for security deposits. 12.26 C. 30 days. Trust accounts must be reconciled monthly within 30 days after receipt of the bank statement. 12.27 C. By any real estate licensee. Although it is called a broker price opinion, it can be prepared by any real estate licensee. 12.28 A. In lieu of an appraisal for approval of a mortgage. A broker price opinion can be prepared for a seller, a buyer, or a lien holder but cannot be prepared in lieu of an appraisal for approval of a mortgage. 12.29 D. The legal description of the property. A brief description of the property is required for a broker price opinion but a legal description is not. 12.30 B. 1 business day. A licensee must give the broker or escrow holder the earnest money within 1 business day. The broker has until the next banking day to deposit the money in the broker's trust account. 12.31 B. Pay all or a portion of it to the seller. Although it is rarely done, unless the purchase agreement provides otherwise, a broker can pay all or a portion of an earnest money deposit to a seller. 12.32 D. Disclose the name of the brokerage firm. In all real estate advertising, the name of the brokerage firm must be disclosed. The other items are typically included but not legally required. 12.33 C. With prominence. In print advertising, the name of the brokerage firm must be clearly identified with prominence. The real estate division will consider style, size, and color, type of font and location of the brokerage firm name. 12.34 C. Richard can only use his licensed name and advertising, not a nickname. In advertising, a licensee may use only his licensed name. Nicknames are not allowed. 12.35 A. Her advertising must be done under the direct supervision and in the name of the brokerage with whom the licensee is associated. All advertising must be done under the direct supervision and in the name of the brokerage with whom the licensee is associated. Sandra's experience and status as a broker salesperson are irrelevant. 12.36 D. For sale by owner agent. A licensee cannot use the words for sale by owner. The phrase for sale by owner agent is acceptable. 12.37 B. All members of the team or group must be associated with the same broker. All members of a team or group must be associated with the same broker. There is no requirement that a team or group to be supervised by a broker salesperson. A team must have more than one licensee and the name of the team or group must include the last name of one member of the team or group. 12.38 D. It must be at least 4 feet by 3 feet. There is no provision specifying the minimum dimensions for a broker's sign. 12.39 A. Upon request by the division, a photograph of the broker's sign is only necessary upon request by the division. 12.40 C. Advertising must include the name of the brokerage firm. Advertising on the Internet is subject to the same regulations as print advertising and therefore must include the name of the brokerage. 12.41 D. Not mentioned in Nevada statutes or regulations. Social media is not mentioned anywhere in Nevada statutes or regulations. State Test 13, Agency and Brokerage, Special Topics 13.1, C. Ethics of the real estate profession. Every real estate broker is required to teach the licensees associated with him or her the fundamentals of real estate or timeshare practice, or both, and the ethics of the profession. 13.2 B. A broker salesperson. A real estate broker may use a real estate broker salesperson to assist in administering the office, as long as the broker does not relinquish overall responsibility. There is no experience requirement for the broker salesperson. A salesperson may not be used to assist in administering the office. 13.3 B. No, but policies and procedures must be established. A broker must establish policies and procedures, but there is no specific requirement to have a written policies and procedures manual. 13.4 D. The brokerage firm's gross revenues. A brokerage firm's gross revenues is not listed in the regulations as one of the factors that must be considered when establishing rules, procedures, and systems. The other factors are specifically listed. 13.5 A. A system for monitoring compliance with policies, rules, and procedures. A system to monitor compliance with policies, rules, and procedures is a specific regulatory requirement. The other answers might be good ideas, but they are not specifically required. 13.6 D. A statement that the broker will supervise associated licensees. A broker can enter an independent contractor agreement with an associated licensee, but that agreement must include the supervision of the broker over the licensees. 13.7 C. A broker's license. Regardless of any other circumstances, Brian is not entitled to any compensation until he first proves that he has a broker's license. 13.8 D. The referral fee should have been paid through Keith and Paula's broker. Referral fees among real estate licensees are legal in Nevada. However, a licensee can only be compensated by the broker or owner-developer with whom the licensee is associated. Payment of the referral fee in this case should have flowed through the broker. 13.9 A. They are negotiable between the broker and the client. Fees are negotiable between the broker and the client, although a salesperson or a broker salesperson may negotiate on behalf of the broker. Establishing fees by agreement among brokers would be an antitrust, price fixing, violation. 13.10 B. Duties owed by a Nevada real estate licensee form. Nevada's agency disclosure form is called the Duties Owed by a Nevada Real Estate Licensee. 13.11 C. The broker and the client. The broker and the client are the only parties to a brokerage agreement. A salesperson or broker salesperson acts on behalf of the broker. 13.12 B. Consent to act form. To obtain the informed, written consent to act for more than one party to a transaction, the parties must sign a form called the consent to act. 13.13 A. 1. Duties owed by a Nevada real estate licensee. 2. The brokerage agreement. The duties owed by a Nevada real estate licensee form must be signed before the client signs any other document. 13.14 C. Duties owed by a Nevada real estate licensee. The duties owed by a Nevada real estate licensee form must be given to each client and any unrepresented party to the transaction. A for sale by owner seller is an unrepresented party to the transaction. 13.15 D. It is not a contract for services. Immediately beneath the title of the document it is noted that the duties owed by a Nevada real estate licensee form is not a contract for services. 13.16 B. Make arrangements with the client so that the duties owed by a Nevada real estate licensee form can be signed before the listing agreement is signed. The duties owed by a Nevada real estate licensee form must be signed before the client signs any other document. 13.17 D. In the purchase agreement, the confirmation of agency relationship must be separate from the disclosure in the duties owed by a Nevada real estate licensee form. The confirmation is often made in the purchase or rental agreement. While the brokerage agreement can create an agency relationship, it does not serve as the confirmation for both parties. 13.18 B. It can be oral or written. Some states require a brokerage agreement to be in writing. In Nevada, a brokerage agreement can be oral or written. 13.19 C. Client and a broker. Only a broker can enter a brokerage agreement with a client. Salespeople and broker salespeople act on behalf of their broker when working with clients. 13.20 A. Property Management Agreement. A property management agreement is specifically excluded from the definition of a brokerage agreement. 13.21 B. From the client or another person. Allowing the broker to accept compensation from someone other than the client facilitates broker fee sharing agreements through the multiple listing service. 13.22 C. Be in writing. A brokerage agreement which includes a provision for an exclusive agency representation must be in writing, be signed, have a definite termination date, and cannot have an automatic extension clause. 13.23 D. Carla's broker and Chandra. The parties to a brokerage agreement are the broker and the client. Salespeople act on behalf of their brokers. 13.24 A. Must be in writing. Unlike some other brokerage agreements, an advance fee listing must be in writing. 13.25 D. Yes. Any oral statement made to induce a person to enter an advance fee agreement becomes a part of the agreement. A broker cannot rely solely on the terms in a written advance fee listing. Any oral statement made to induce a person to enter an advance fee agreement becomes a part of the agreement. 13.26 D. Yes, if she should have known about the defect, a real estate licensee has a duty to disclose material facts she knows, or which through the exercise of reasonable care and diligence, should have known relating to the property. The licensee's duty is independent of the seller's duty to disclose defects in the seller's real property disclosure form. A licensee specifically does not have a duty to conduct an investigation of the condition of the property. 13.27 B. Disclose the leak to any buyer. A real estate licensee has an independent duty to disclose material facts relating to the property. Facts relating to the condition of the property are not confidential. 13.28 A. Legally liable for her own conduct. A real estate licensee is always legally liable for her own conduct. A broker is vicariously liable for the conduct of all associated licensees. 13.29 A. Non-agency. Nevada does not recognize any non-agency relationships with the client. A broker always has some kind of agency relationship with the client. 13.30 B. Is not required to have a real estate license. A personal assistant in Nevada is not required to have any kind of license, permit or certificate. 13.31 B. The listing agent must disclose that Tiffany's grandmother is contributing to the commission, but she is not required to disclose the amount. A real estate licensee is required to disclose each source of compensation but is not required to disclose the amount. 13.32 A. Yes. A licensee's duty to disclose material facts relating to the property cannot be waived. The duty of confidentiality does not extend to material facts relating to the property. Even a small leak could be a material fact to a buyer. 13.33 C. No, it is not a material fact relating to the property. A licensee owes a duty to all parties to disclose material facts relating to the property. The seller's desperate financial situation might be a material fact, but it does not relate to the property. 13.34 C. Yes. It is a material fact concerning the transaction. A licensee owes a duty to her client to disclose material facts she knows concerning the transaction. there is no legally recognized duty of confidentiality owed to a non-client friend. 13.35 d. Any information that could affect a person's decision. A working definition of a material fact is any information that could affect a person's decision. Material facts relating to the property must be disclosed to all parties. Material facts concerning the transaction must be disclosed to a client. 13.36 b. Yes. He must disclose it to all parties to a transaction. A real estate licensee must disclose the fact that he is a principal in the transaction or has an interest in a principal to the transaction. The size of Tom's small percentage interest in the corporation is not relevant. 13.37 b. Yes. A Nevada real estate licensee must disclose the fact that she is a principal in the transaction. It does not matter where the property is located. 13.38 b. Acting for more than one party to the transaction, i.e., dual agency. Marjorie's broker is representing the buyer and seller without using an assigned agency. This means Marjorie is also acting for the buyer and seller and is, therefore, a dual agent. 13.39 c. He must advise the seller that his agency relationship to the seller has changed. Bill started as a single agent for the buyer. His relationship changed when Bill's broker assigned Bill to represent the seller. Bill is now an assigned agent and not a single agent. A licensee must disclose any changes in the licensee's relationship to a party to the transaction. 13.40 a. He must disclose that he is acting for more than one party to the transaction and obtain the necessary written consent. Harvey cannot be an assigned agent unless his broker makes an assignment. Harvey is not required to refer one of the clients because acting for more than one party to the transaction is allowed in Nevada. Harvey must disclose that he is acting for more than one party to the transaction and obtain the necessary written consent. 13.41 c. Transactional brokerage. A transaction broker represents neither party as an agent, but works to assist both parties equally. In Nevada, a real estate licensee must represent someone in the transaction. Transactional brokerage is not recognized. 13.42 a. Consent to act form. Assigned agency is not being practiced, so Nancy and Pam are acting for more than one party to the transaction, i.e., multiple representation. They must obtain signatures on the consent to act form. The other forms don't exist. 13.43 a. Broker. In Nevada, only a broker can independently represent a client. The other licensees act on behalf of a broker to represent a client. 13.44 c. Reasonable skill and care. As to all parties to a real estate transaction, a licensee owes a duty to exercise reasonable skill and care. Fiduciary duties are only owed to a client. 13.45 a. All parties to a transaction. The duty to disclose all sources of compensation is owed to all parties to a transaction, including a non-client. 13.46 b. The client. A duty to disclose material facts relating to the property is owed to all parties to the transaction. A duty to disclose material facts concerning the transaction is only owed to a client. 13.47 d. Advise the client to obtain expert advice. Desiree must advise the client to obtain advice from an expert relating to matters which are beyond the expertise of the license. 13.48 d. Duties owed by a Nevada real estate licensee form. The duties owed by a Nevada real estate licensee form is the only one listed that specifically must be given to the client and an unrepresented party. 13.49 b. To obtain authorization for a real estate broker to act for more than one party to a transaction. Before a broker can act for more than one party to a transaction, the broker needs the informed written consent of all parties. The consent to act form is used to advise the clients of the conflict of interest and obtain their written consent to the multiple representation. 13.50 c. To conduct an investigation of the condition of the property. By statute, a real estate licensee does not have a duty to conduct an investigation of the condition of the property. All of the other choices are specific statutory duties. 13.51 d. No, a licensee does not have a duty to conduct an independent inspection of the financial condition of a party to the real estate transaction. By statute, a real estate licensee does not have a duty to conduct an independent inspection of the financial condition of a party to the real estate transaction. 13.52 a. Maintain confidentiality. A real estate licensee owes a duty of confidentiality to his client but not to the other parties to the transaction. The other duties listed are owed to all parties to the transaction, not just a client. 13.53 b. His client a duty to disclose material facts concerning the transaction is owed to a client. A duty to disclose material facts relating to the property is owed to all parties to the transaction. 13.54 c. He must present it to Francis. All offers made to or by a client must be presented until an escrow closes. 13.55 d. Yes. She must present all offers. A licensee must present all offers made to or by a client without regard to the amount offered. 13.56 a. Consent to act. The consent to act form is needed to act for more than one party to a transaction. It discloses the conflict of interest and authorizes the representation. The duties owed by a Nevada real estate licensee is required in all transactions, but it is a disclosure form only and does not authorize acting for more than one party to the transaction. The other forms listed do not exist. 13.57 c. As soon as practicable. Two statutes cover when an offer must be presented or tendered. One states as soon as practicable and the other says promptly. There is no specified time period. 13.58 b. 35 or more land must be divided into. Oregon proposed to be divided into 35 or more lots before Nevada's subdivided land law is applicable. 13.59 a. Public offering statement. A public offering statement must be reviewed with every prospective original buyer of a timeshare. 13.60 b. The doctrine of prior appropriation. This means that the first person to use water or divert water for a beneficial use or purpose can acquire individual rights to the water. 13.61 C. Timeshares and campground memberships. A sales agent, sometimes called a timeshare sales agent, is a license level lower than a salesperson. Under the supervision of a project broker, a sales agent can only sell timeshares and campground memberships. Simulation test, Nevada License Examination Simulation Test S1.